The Lordship's kind permission. One matter for 2:30, end of the list. Electricity has been disconnected yesterday. Now, over the weekend, I'll not be without electricity. Kindly have it.
If it is by 1:30, because court is not setting it afterwards.
Please, Lords, I shall.
Yes.
My lords, this is executing court. Tomorrow the matter is listed for executing the decree. I've
When
been
was
having
it
the.
passed?
My lords, the order was passed on 2nd. I have already preferred an SLP. During the pendency tomorrow, they want to dispose me. Therefore, my humble request is maybe taken up in the
When you
afternoon.
preferred an SLP,
Yes, my lords.
pursue there.
Vacation bench, my lords. So they have posted it for regular bench. Despite that, the Honorable Supreme Court, I'm told, has said that it may not let the executing court not do anything.
Have two remedies, one before the Supreme Court and one before this court.
No, my lords, I'm only requesting 17/7, the matter is listed before Supreme Court.
That's what I'm saying.
Yes, my lords.
This is not like whatever has to be passed, because the matter is pending before Supreme Court. We will not pass any interim order till the.
My lords, we have specifically told the executing court it's on 17/7. Kindly have it after that. The court has said nothing. Tomorrow I'm going to have it and I'm going to pass an order for attachment. I'm only requesting that it may be taken up after that. That's all my request is.
Why should we say so? That Supreme Court has to say.
My lords, it will become infructuous there, my lords, because the regular bench is going to sit only in July, my lords.
Court to interfere in order which the Supreme Court has not granted, that we will not clarify to the trial court.
My lords, if it is possible, if your lordship can hear me in detail, because 30 years I've been having this property, I'm a liquidator in this. This is going to affect the banks ultimately.
But I'm not going to take it up now. Yes.
My lords, the delivery warrant is issued already. Execution proceedings. I'm in the possession, and my application on
Delivery warrant issued.
2nd June, my lord, and I'm in the possession, and my application has been rejected on the ground that I have filed a suit. Now I'm ready to withdraw the suit. I filed the suit on the liberty given by the apex court, my lord. I'm in the possession, and after I filed the suit, execution proceedings were initiated, and now I'm ready to withdraw my suit, and I'll contest my grievance in the execution proceedings. My lord.
Time fixed for the execution of the warrant.
The next date is 17th, my lord.
Which time is that?
Lord, kindly hear me, my lord. But
Why should we
2:30.
hear you? When is 17th? File it will come in its own course. Yes.
Kindly have it on Tuesday, my lord.
If you file
Call
it,
the
will come.
application.
My case was moved to 8th. I need to stay by 11th. Can it be done a little earlier? It's now listed on 8th, was yesterday, moved to 8th. Can it be done a little earlier?
Why?
I need to get it before 11, so I just want some time. Because there is the hearing coming up on 11, so I need to stay before that.
So when do you want?
If I can hear today or tomorrow.
You want, what is Monday?
8th.
Then?
So I'd like a little earlier because if yes.
What earlier than Monday? Tomorrow is a holiday.
Today afternoon?
No. Yes, call the list.
Your lordship, and India, your lordship. Executing court is proceeding as the company.
I said you please give the memos to the court officer and matters will list. I will not take it up at on the 1:30 or 2:30.
Not pending. I need it next year.
Whenever give it to the court officer, it will be added to the list.
This post matter for being spoken to, my lord.
Yes.
That externment order and the vacation bench, your lordship had passed. The stay is still, there is some confusion on when the stay will operate. So on that for being spoken to, my lord, I'm moving. It's Monday, my lord.
Monday.
Obliged.
All this for being spoken to in the first list.
My lord, only one submission. My lord, there was a message I have taken in the midnight of 11:45 from the other side of advocate who I don't know who has going to be taken end of the list ಅಂತ ಕೇಳಿದ್ದಾರೆ ಅವರು. ದಯವಿಟ್ಟು ಎಂಟರ್ಟೈನ್ ಮಾಡಬೇಡಿ. ನೆನ್ನೆ ಇದ್ದಿದ್ದ ಮ್ಯಾಟರ್ನ ಇವತ್ತು ಮತ್ತೆ ಹಾಕೊಂಡು ಮತ್ತೆ ಇವತ್ತು ಎಂಡ್ ಆಫ್ ಲಿಸ್ಟ್ ಮೂವ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Which matter?
12554 of 2026 WP. ಅವ್ರು ಆ ತರ ಏನಾದ್ರು ಬಂದ್ರೆ ದಯವಿಟ್ಟು ನಮಗೊಂದು ಅವಕಾಶ ಕೊಡಿ ಸ್ವಾಮಿ.
What is that you saying?
They are unknown persons.
Call the list.
Page-wise attendment, list number 1, page number 1, serial number 2 to 4, page number 2, serial number 5 to 14, list number 2, page 1, serial. These are all dismissal. List number 3, page number 2, serial number 8, page number 3, 9 to 13,
My lord, serial number, 1 second. 14 and 15, my lord.
Page number 4, serial number 14
14
to
and
20.
14. Cast list. Any date, my lord, in next week. My senior is,
Ask for a date, it will go after, in the month of July.
no, my next week, my lord.
No,
See,
no, no.
My senior
When
is
the
not.
matters are listed, you please argue. Otherwise, I can't, because there are so many matters pending.
Please,
Every
my
day
lord.
they are
My
coming up
senior
with
is
hundreds of
not well, my
memos.
lord. That's why, my humble request, my lord. Next week, any date, my lord.
Does this matter? Anyhow, it will go into hundreds if it is next week. Does the matter next week and on Wednesday?
List number 1 for orders matter, serial number 1.
Matter, my
Parikshit.
lords, I appear for
Present.
proxy counsel in this matter, my lords. See, the counsel on record, my lords, his father having some ill health, my lords. He's admitted in hospital, my lords. Kindly have it on Monday or Tuesday, my lords. And maintainability, my lord.
He is seeking an order to set aside the judgment and decree.
Please, my lords.
How can it be
R7
done?
Rule 11, my lords.
Huh?
It is a maintainability for the application,
No, no, it is not the application.
my lords. Whether the application fall in the WP or CRPC, my lords. That is the maintainability, my lords. In that, my lords, we have to argue on that, my lords.
Oh, order 7, rule 11.
Yes, my lords.
The office has raised objection with regard to the maintainability of the writ petition. As it is questioned against an order that's passed, that's against an IA under order 7, rule 11A and D of CPC. Office objections are sustained. Petition is permitted to convert this into a CRP within a period of 1 week from the date of receipt of the copy of this order. And for statistical purposes, this writ
The
petition
hearing,
is
serial number
disposed of.
2. Rupesh Abhi.
Publish.
Appear for
Yes.
petition, my lord.
Yes.
My petition is the plaintiff before the trial court. A suit for declaration is filed, my lord. Wherein, my lord, I have led my evidence. 2 times, my lord, I have filed
For the
application.
plaintiff,
Plaintiff, my lord.
suit for declaration.
Declaration. 2 times I have filed, my lord, application for production of documents. Both are allowed, my lord. After closing my evidence, my lord, I got, my lord, some documents. Then third application is filed.
You will keep on doing it till the
No, no,
suit
no.
is decreed.
Only
That is not, let's see. How many times you will file? Where is Agnew?
my lord, application is at, my lord,
Yeah,
page number
2018.
153.
50?
153. Anakshar L.
Certified copy.
Court was of the opinion that, my lord,
Incumbent certificate of 1989, representation of 2015, representation of 2018, representation of another one 2018, certified copy of writ petition
writ petition is recent
of
one.
the sale deed dated 6/12/97. Let's see the affidavit.
Writ petition copy is, my lord, recent. That was observation made by the court also, my lord.
I submit that the above matter was posted on 4/2/2026
I have read,
for
my lord.
further evidence. I have not produced documents, relied on the plain governments and make the documents through my side. The certificate of the documents are very much necessary to prove the plain governments. Hence, it is just and necessary to permit me to produce the documents. Unfortunately, due to oversight, you have not produced the documents. Please come to the order. Where is the order?
My lord, I think page number 16, from 169 it is relevant, my lord.
169.
9 in the. 168. 168 in the. After completion of the pleadings on 4/11/2021, the issue was framed. 168.
What is this? The applications are filed by the advocate.
My lord,
IA number 22 is filed under section CPC.
to recall, my
order.
lord, since,
What
my
is that
lord,
order?
PW1 was, my lord, recall, was closed, my lord. Recall, reopen and to file this document. 3 applications were filed. Earlier applications were referred by the court, my lord, in the order. After completion of the pleading and for an issue was framed, the case was posted for plaintiff evidence on 23/9/2022. From the date till 2024, evidence of plaintiff was not commenced for the different reasons.
You're reading where?
168 page number.
Read from the reasoning part, para 7. The suit
Reasoning one.
is filed on 25/4/2018.
Yes, my lord.
From there you read.
After completion of the pleadings on 4/11/2021, issue was framed. The case was posted for plaintiff evidence on 2022. From the date till 2024, the evidence of the plaintiff was not commenced for different reasons, my lord. On 2/12/2024, the plaintiff too examined PW1. Further examination deferred. On the same date, the advocate for plaintiff filed IA number 12 and order 7 rule 14 for CPC production of documents. The application was allowed on 10/12/2024. Exhibit P1 to P123 were marked on behalf of the PW1. Again, advocate for plaintiff pressed time for further examination. It was adjourned on 13/11/2024. 1/2/2025, 1/2/2025. Again on again IA number 13 under order 7 rule 14 was filed for production of documents is filed. It was allowed on 5/2/2025. On 18/2/2025, PW1 further examined on chief. Exhibit P to 124 to 125 were marked. The case was posted for cross-examination of PW1 on 9/2025 and 19/2025. Again, advocate for plaintiff filed IA number 14 under order 151 of CPC to recall IA number 15 under order 18 rule 17 to recall PW1 and further examination. IA number 16 under order 7 rule 14. These applications are allowed on so and so date 11/6/2025 by imposing cost of rupees 6,000. On 25/6/2021, PW1 examined in chief on
Yes, I've
PW.
seen. Not a case.
Only one another reason, my lord, the court also noticed that, my lord, writ petition order was recent 2026.
Yes, please come. You don't even say, how is it relevant? The agreed with orders passed on I number 22 to 24 dated 7/4/2026. Invoice number 31. What is the number?
And IA number 24.
3143 of 2018. The no, IA number 22.
22, 23, 24.
24. Invoice number dated so and so by so and so. The plaintiff is before this court. The plaintiff has filed the suit for declaration and injunction.
Yes. Declaration and mandatory injunction.
Declaration and mandatory injunction. The suit is filed in the year 2018. Now, the present applications are filed by the plaintiff. Under order 7 rule 14A to produce him to permit him to produce the documents, that is 10 in number. It is stated that in support of the affidavit, it is stated that the matter was posted on 4/2/2026 for further evidence of the plaintiff. He has not produced the documents relied on. The plaintiff elements were not produced and the documents are not marked. The certificate copies of the documents are very much necessary to prove the plaintiff amendments. Hence, it is just unnecessary to permit the plaintiff to produce the documents and mark to him. Hence, he has come up with the application. He could not file these documents due to oversight. Hence, he was permitted to mark these documents and also file application to recall and for further evidence. The court, by order impugned, had dismissed this application. Learned counsel appearing for the petitioner submits that one of the document which the petitioner is relying on is of the year in order passed in the red petition in 2025.
2026,
which was not in the possession of the petitioner. As such, petitioner further it is submitted that all these documents are very much necessary for the effective disposal of the case and to prove the case of the plaintiff. The court, without considering the same, had dismissed the application just because the petitioner has filed the applications 2 times on 2 other earlier occasions. That cannot be the ground for the court to dismiss the application. Next one. Having heard the counsel for the petitioner, there is a material on record. The trial court, while dismissing the application, has observed that the suit is filed on 25/4/2018, and after completion of the pleadings on 4/11/2021, the issues were framed. The case was posted for plaintiff's evidence on 23/9/2022. From the date till 2/12/2024, the evidence of plaintiff was not commenced for different reasons. On 2/12/2024, the plaintiff number 2 examined as PW1. Further chief examination is deferred. On the same day, the advocate for plaintiff filed I number 12 under Order 7, Rule 14 of CPC for production of documents. The application was allowed on 10/12/2024. Exhibit P1 to P123 were marked on behalf of PW1. Again, advocate for plaintiff prayed time for further chief examination. It was adjourned to 13/11/2024, 1/2/2025. On 1/2/2025, again, I number 13 under Order 7 Rule 14 CPC for production of the documents is filed. It was allowed on 5/2/2025. On 18/2/2025, the PW1 further examined in chief. Exhibit P124 and Exhibit P125 were marked. The case was posted for cross-examination of PW1 on 19/3/2025. On 19/3/2025, again advocate for plaintiff filed I number 14 under section 151 CPC to recall the order, I number 15 under Order 18 Rule 17 CPC to recall PW1 for further chief examination, I number 16 under Order 7 Rule 14 of CPC. All these applications were allowed on 11/6/2025 by imposing cost of ₹6,000. On 25/6/2025, PW1 was examined in chief and Exhibit P26 to Exhibit P128 of marked. Finally, the cross-examination was completed on 13/1/2026. On the very next day of hearing, the applications are filed. The court, considering the judgment of the apex court in KK Veluswamy versus N. Palaniswamy, reported in 2011 ARSCW 2296, and also and the judgment of the apex court in Bagai Construction PROP versus Mrs. Gupta Building Material Store, reported in 2013 14 SCC 1, and also Padiraj Nagappa Varnekar versus Charachandra Prabhakar Gogate, reported in 2009 4 SCC 410, has held that, has observed that in view of the settled law, these applications, consecutive applications, cannot be allowed and accordingly dismiss the petition. The petitioner, so far, petitioner has filed 3 petitions consecutively, and 2 petitions were allowed, and 3rd petition was allowed on cause. And again, he has come up with this petition. When an application is filed, though even at a belated stage, court would consider the same, basing on the facts and circumstances and in the interest of justice. But this is a case where the court has already exercised the jurisdiction on several occasions and accommodated the plaintiff by allowing the earlier applications. But filing this application is nothing but a pure abuse of process of law, and the court had rightly dismissed the petition. This court finds no reasons to interfere. Accordingly dismissed.
Cell number 3. Write the date for that.
No representation. List this matter for dismissal in the month of July. Don't give the date.
Cell number 4. SV Bhatt.
For the question in this case. Kindly excuse me, in all entire pleadings, including the order, is in vernacular language, Kannada.
When can you file if there is urgency?
Within 10 days, my lord.
Yes, this matter on 17th of June. By the time the council shall place before the court the translated copies of the documents which are in vernacular language.
Including the order, madam.
Everything.
Much.
Cell number 5, Ashoka T.
No password.
No, that senior is in.
Ask him to come before 1:30 or else it will go. Yes.
Cell number,
I'll call the password at 1 o'clock.
cell number 6, P. Mahesha.
No representation for dismissal in the month of July. Don't give the date.
Cell number 7, Ravish
Or
Kenny.
petitioner please, ma'am.
Yes.
There is calculation mistake made by the DHR please, ma'am. We have deposited the entire amount before the tribunal at annexure D please, ma'am.
Page number.
Page number 15 please. They have not calculated they have calculated interest on 25,000 which are deposited before this court and also stay compliance order and also final amount deposited by the company please, ma'am. Now we calculate the interest on entire amount please, ma'am. Therefore the difference amount is clear. Well, at annexure B, last line please.
13,000.
30, already it is also deposit.
No, what is the difference amount I'm asking?
97,000 please.
Where is your calculation memo?
It is annexure D please.
How it is considered by the court, let us see.
Please, ma'am.
Let us see the order of the court.
Not the letter counsel for the judgment data filed calculation so and so date. You have about the entire amount before the 2023 only itself.
We'll read
Please,
the
please,
order.
please, ma'am. Stating that in pursuance of the judgment passed by the High Court of High Court in MFI number so and so both and have deposited the amount along with the accrued interest. Further stated that the balance amount 97,000 remains payable to the decree holder to the decree holder. The said amount is calculated the opposite the decree holder. Heard and the learner counsel of both the side peruse the
So,
memo.
let's see what's wrong with the calculation.
Yeah, Lord, kindly turn the action B please, ma'am.
Page number.
Page number 11 please, ma'am. Last line. The interest calculation 6% on 5,60,000 for 8887 and calculate.
Award amount is 4,27,999.
Please, ma'am, please.
Interest at 6% per annum from 5/1/25 to 1/3/2018 is a disposal date.
Please, ma'am.
Huh?
Please, ma'am.
Huh.
Again, total amount comes to,
That comes to 5,08,812.
again, what in stay compliance or deposit, we have deposited the 2,09,637. Along with interest payment, it comes to 2,97,000. Again, the 83,000 has been calculated, please.
What is this? Deposited on 1/3/2018, you said 2,09,637.
With,
So the remaining amount according to is 2,99,175.
please, ma'am. Again, it comes to 3,82,521 ಹೇಳ್ತಾರೆ. Again, the less deposit amount 4,13,429.
No. On 2,99,175, which is due, the interest is 83,000.
18 to 2022, please.
350, huh?
18 to 3,018 to 79,022.
83,356
Please, ma'am.
interest.
Deposit.
So that it comes to 3,82,531.
Please, ma'am.
531.
Please, ma'am.
Deposited on 79/2022, 3,14,000.
Please, ma'am.
729.
Yes, ma'am.
Then the remaining.
Again, calculate interest on,
It is, the amount remaining is 67,802.
please, ma'am.
Interest at 6% per annum from 79 to, on this amount.
568.
568. It comes to 68,370.
Oh.
Deposited on 8/11/2022.
Please, ma'am. 26,970.
28,799.
Please, ma'am.
So under the remaining amount is 39,580.
Please, ma'am.
Again, interest is on 4,000.
4,000.
43,580.
Again, interest on for entire amount is calculated.
Where?
The last line, interest on 6% on 5,67,887.
From 23/1/20.
Again, he calculate the interest against the interest, please, ma'am. Interest against the interest for entire amount.
No. Interest at 6% from 9/11/2022 to 23/7/2024 is 4,000. So as on 23/7/2024, the outstanding is 43,580.
It's already done, please, madam. Again,
What done?
50,970.
No. As on 23/7/2024,
Please, ma'am.
there is an amount of 43,580 due.
Please, ma'am.
There is no dispute on that.
Please, please.
Then interest at 6% per annum on five, oh, this is
That,
again,
please, ma'am. That is my humble
entire
request.
amount. Where from this 5 lakhs has come?
That is wrongly filed a memo of collection by the DHR, please.
Then when did you deposit the next amount?
For
No.
entire amount to deposit before on 9/10/2023 itself, please, ma'am. Annexure D.
Where did you deposit? As on, you also does not dispute the fact that as on 23/7/2024, you have to pay 43,580.
That's correct, please, ma'am.
Then where is that amount? When did
Again, he calculated the interest on 5, 6.
Forget about it. What about this 43,580? When did you pay that?
That is we are disputing, please, ma'am. Again, he calculated the interest
I
on.
understand this, that they have calculated the interest on 5,66,000. I am asking you about an entry before that.
43 is not disputing, please, ma'am.
And
He
then
he calculated the interest.
Forget about it. That 43 you have to pay.
Please.
Then you pay that.
No, as per our calculation, only 13,000 you have deposited also, please, ma'am. Again, kindly last
Tell
calculation.
me, when did you deposit this 43,580?
Again, next line, please, ma'am. Next line. He calculated the interest on 5 lakhs entire amount. It comes to 93,000 and 3,000. That is we are disputing. We are not, there is no even single rupee balance before the tribunal. Entire amount has been deposited. There is single.
You just can't say one simple sentence, everything is deposited.
Please.
You're relying on this document. I'm also looking at the document.
It is a calculation made by the DHR, please. Now, some calculation had an extra D, please, ma'am.
And in this calculation, you are only disputing this part.
97,000 we are disputing, please, ma'am. There is no balance at all. 30,000 balance you deposited also.
50,000, you are disputing this calculation of interest of 50,972. Then they have added 43,000 plus 50,000, it has become 94,000. But 43,580 you are not disputing.
That we are disputing that amount also, please, ma'am. That's why I am humbly requesting that kindly issue notice to them. Let them give the payment of collection. If I are unable to.
I will not grant stay unless until I am satisfied. That is what it is. So you have to convince me basing on the calculation. I can understand that they have calculated the interest right from the beginning. That is bad.
Please,
that comes to 50,972. But 43,580, you are not disputing at all while you are making your submissions now.
39,040.
43,580. You are disputing this 50,972.
50,000 plus 90 plus calculation model 97, totally 97,000.
It will come when 43 and 50 is added. That it will become that only.
Then I will deposit with this amount, please, ma'am. Kindly stay the balance.
43,580 you deposit.
Please.
Please come. The insurance company is agreed with the order passed by the court dated 28/2/2026, whereby the court has directed the insurance company to deposit an amount of rupees 97,252. Then counsel for the insurance company has drawn the attention of this court to the memo of calculation that is filed, wherein, as per the calculation, interest at 6% per annum from 9/11/2022 to 23/7/2024 is 4,000, and the outstanding amount is 43,580. In the next column in the calculation, it is mentioned that interest at 6% per annum on the entire amount, that is 5,66,887 from 23/1/2023 to 24/7/2024 is 50,972, and it has come to 94,552, and the cost 1,500, and the fee of the advocate 1,200. It comes to 97,252. Land counsel submits that when already the claimant has calculated the interest right from It is submitted that the interest of calculation on the entire amount cannot be from 23/1/2023, as already insurance company has paid the interest, has paid the amounts on at different intervals, and that is also uh, uh, that is also stated in the memo of calculation. This court has perused the memo of calculation that is placed before the court. And as far as 43,580, which is outstanding as on 23/7/2024, is not disputed. In that view of the matter, there shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that the insurance company shall deposit 43,580 within a period of 2 weeks.
4 weeks, please.
Why? This is not an appeal.
Check should be down from the Madras from head office.
Within a
That's
period of 4 weeks.
before tribunal, please.
Before the tribunal, within a period of 4 weeks from today. Notice to the respondent.
Kindly stay the matter tomorrow. The execution.
Yes,
Number 8. Ishan GK.
I appear for the petitioner, my lord.
yes.
The petitioner is the plaintiff in a commercial suit before the Commercial Court, Bangalore. Suit is filed for recovery of money of about 94 lakhs. Arises out of a contractual arrangement in the investment banking industry, my lord. Some referral fees was to be collected. The suit is filed on 16/7/2025. The defendants enter appearance, my lords, and on 20 September 2025, an order 1 rule 10 for deletion is filed. That is decided on 5th of January 2026. Subsequent to that, the defendant again files a 7 rule 11, my lords. That is decided on 3/3/2026, 3rd March 2026. I have filed, my lords, my affidavit. He files his written statement on 1st of December 2025, and issues are framed on 17/1/2026.
1st December,
My lords,
1st December 2025 is a written statement.
written statement. 17th of January 2026 is issues are framed. I file affidavits of both my witnesses, PW1 and 2, on 18th of March 2026. On the 26th of March, my lords, I file an application for production of documents under Order 11, Rule 1, Sub Rule 5. My lords, the objections are filed. My specific contention in the application is that this is in order to meet a defense that is taken by the plaintiff in the written statement. And since he denies a particular aspect of the transaction and denies certain documents that I have filed along with the plaint, it is necessary for me to file this. This application is rejected by the impugned order, and I am before your lordships in that. Now, the two aspects, my lord. One is I have done everything by the clock. My witness is also in the box. The defendant has filed 2 applications, one for deletion, one for rejection. Both have been turned down. He came up to High Court in appeal. I have done absolutely everything by schedule. The second aspect is, my lord, the impugned order returns a finding at page number 34. If you'll
Go to your IA.
please, my lords. Page 112, my lords. If your lordships are kind enough to take page 120, my affidavit starts at page 119.
Yes. Yes.
If your lordships are kind enough to take para 4 at page 120.
Yes.
I state that in the plaint filed in the present suit, plaintiffs have specifically pleaded in paragraphs number 19 and 26 that the transactions between so-and-so and so-and-so was of a value exceeding 170 crores, which averments have been denied by the defendants in the written statement. I state that in view of the denial made by the defendants regarding the value of the transaction, it has become necessary for the plaintiffs to produce statutory records and financial disclosures evidencing the actual investment value of transactions between so-and-so and so-and-so. Then, my lords, I explain the nature of the documents. These are statutory filings. I give each a description of each of the documents, my lords. Kindly, my lords, come to paragraph 18, which is at page 123. I state that the aforesaid documents demonstrate that the investment transaction taken between so-and-so and so-and-so consisted of multiple primary and secondary investment tranches carried out over a period of time. I state that the cumulative effect of all the above documents clearly establishes that the total transaction value was substantially higher than 40 crores, which was represented to the plaintiff and was in fact in excess of 170 crores. Transactions concluded in March and April 22, and higher than 200 crores when all transactions from so and so to August 24 are considered. The finding, my lords, in the impugned order, which I am aggrieved by, kindly see at page 34. The first line which starts on page 34. These documents are not sought to be produced to answer any claim or defense set up by the defendant subsequent to filing of the plaint. And there is, my lords, no prelude or preamble. The law laid down by.
No, you're reading at page 24.
I'm reading at page 34, my lords.
30.
My apologies, my lords. It's internal page 14 of the impugned order, inks page 34. The first line. These documents are not sought to be produced to answer any claim or defense set up by the defendant subsequent to filing of the claim. This is my precise case, my lords.
When the documents were readily available with the plaintiff, which he could have immediately taken out from the website of being the public, and there was absolutely no impediment to produce the same along with the suit.
These are public documents, my lord.
When was the written statement filed?
Yes, my lords. 1st of December, my lords.
When is this IA filed?
3rd of March. My apologies. 26th of March.
Then what were you doing from then till?
My lords, what happens is that I filed my list of witnesses on the 28th of issues are framed on 17th, and a specific issue regarding the value of the transaction is framed. The there is an order, an application under 7 Rule 11, which is filed on the 5th of February 2026, and that goes on until 3rd of March. My lord, I succeed in the 7 Rule 11 until the 3rd of March. Your lordships will find that in the order sheet that is produced.
Please come.
First, my lords, if my lords,
I've seen it, Land Council. The petitioner is agreed with the orders passed in. I number 7 in COM OS number 996 of 2025, dated 23rd April 2026, with the application filed by the petitioner under order 11 rule 15 of the CPC for protection of the additional documents, along with documents, came to be rejected. It is a case of the petitioner, who is a plaintiff in the suit, that the suit is filed on 16/7/2025, and thereafter, after the defendant entering appearance had filed an application under order 1 rule 10, then has filed an application under order 7 rule 11, which went on till 3/3/2026. Thereafter, and both the applications came to be dismissed. Thereafter, a written statement was filed. No, a written statement was filed on 1st December 2025. In the written statement, a particular plea was taken that the defendants have. Where is your affidavit?
yes, my lords. My affidavit is page 119, my lords.
The defendant in the written statement has denied the value of the transaction. As such, in support of the same, the plaintiff wants to mark certain documents. Land Council submits that right from the inception. But the plaintiff, as per the timeline fixed, was going ahead with the matter in the court without considering the fact. The court in the impugned order has observed that these documents are not sought to be produced to answer any claim or defense set up by the defendants subsequent to filing of the plaint. It is submitted that this goes contrary to the pleadings in the affidavit filed by the by the by the plaintiff. This court has perused the affidavit. Next para, this court has perused the affidavit that is filed and the finding at paragraph number 11 of the order. In that view of the matter, there shall be stay of all further proceedings pursuant to the order dated so and so in so and so. Petitioner is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to the defect by 22nd. This is matter on 23rd. By 22nd, if the memo is not filed, the stay granted with this court stands located.
I'm deeply obliged, my lord. I'm so obliged.
Case number 9. Nagaraj.
Defendant's writ petition, my lords, questioning the order, my lords, in dismissing my application seeking recall of PW1.
Recall of PW1. When was the evidence of the plaintiff concluded?
Lords, on 17/11/2025, lords, the entire suit was decreed.
Decreed.
Suit decreed, and lords, in appeal, lords, the suit has been remanded.
When was the remand?
17/11/2025, lords.
Is the remand?
Yes, lords. Subsequently, lords, an issue has been framed by the trial court, lords, and in respect of will.
What is the scope of remand?
Lords, to frame an issue and lead evidence.
Only as far as that it is.
Will, yes, yes.
What was the issue?
To prove the will, lords, by the defendants.
To reduce the evidence for.
Yes, yes, yes. Lords. I have led my evidence, lords.
When were the issues, that issue is framed?
Please. That issue 6/1/2026.
Yes.
After lords, simultaneously, lords, the notice was also issued to the defendant number 5. That process was completed, lords, only on 24/3/2026. Subsequently, lords, the case was posted, lords, for leading evidence by the plaintiff. On 23/4/2026, lords, on the submission of the plaintiff saying that they have no evidence, it has been posted for the defendant evidence. The defendant, lords, has led his evidence, lords, on 21/4/2026.
21/4/2026.
10/4/2026, lords. And lords, she was fully cross-examined, and simultaneously, lords, the plaintiff defendant has also filed an application, lords, seeking recall of the witness, which has been dismissed, lords, on the ground, lords, that there is no reasons in the application, and lords, there is a time frame to close the suit.
Let's see. Let's see your IA.
Please, lords. The main reason, lords, for filing IA, the will, lords, which is.
Let's see that.
Please,
Let's see that.
page number 58 is my IA, lords, and 59 is my affidavit.
Let's see that affidavit.
Paragraph number 3, my reading.
Yes. Para 3.
Yes, Mr. I said that first instance, after framing of issues by this honorable court, both the parties have led their evidence, and after completion of the same, this honorable court was pleased to dispose of the above suit. On appeal by us before the Honorable High Court, the above suit was remanded with a direction to this honorable court to frame further issue in respect of proving of will, which has been produced by us, and accordingly this honorable court was pleased to frame the issue in that regard, and on the said issue I have led my evidence and fully cross-examined by the plaintiffs. In this regard, I am required to lead further evidence of one more witness, and since the plaintiff has not led any evidence after remand for and framing.
What was the time frame fixed by the court?
Before summer vacation.
It's already over.
Yes, much. Lords, for leading evidence only 4 weeks was available. Lords, the notice was completed only in end of March.
Then we'll give a day, in one day let them complete.
Yes,
it.
yes, that I do.
Lords, for this reason, Lords, kindly refer to page 60, my lords, for which reason he is seeking for recall of PW1. My lords, not for further evidence of defendant. Lords, DW1 has been examined to prove the will. He has not led in further evidence, my lords. Now he want to seek the recall of PW1. The reason is at page 60, my lords. Since, my lords, first line, since the plaintiff is also a beneficiary to the will produced by exhibit D5 and D14, and the burden of proving the will is based on us, based on the issues framed by the honorable court, it's just unnecessary for me to cross-examine PW1 in this regard. My lords, other than this, my lord, there is no reasons aside for recalling PW1. The burden is on the defendant to prove the will, my lords.
When was the defendant plaintiff cross-examined?
Manoj, in the year 2024 itself.
No, after this.
After this, plaintiff was
After
not,
the-
Manoj, I have not laid
laid
any
their
evidence.
Huh?
It's a suit for partition. I have not laid evidence. Manoj, my evidence was closed before, Manoj, before when the matter was remanded back.
Why for proving, after an issue is framed, if why the parties cannot be?
Manoj, the written statement, Manoj, after the suit is filed, their specific statement before the written statement is that they have filed, they have acquired the property by virtue of the will. Manoj, before the order of remand, Manoj, before the judgment is passed, they are not proved the will. Manoj, there is a pleading in the written statement that they are claiming a right on their will
Will executed by whom?
by the mother-in-law, father-in-law. Manoj, where 1.5 gunta each.
What is the relationship between the plaintiff and?
Manoj, defendant is the daughter-in-law of Munshamappa. That is my sister-in-law.
plaintiff's brother's wife.
Manoj, where the entire, this is ancestral property, will alleged to have been executed by Munshamappa, that is my father, where Malats 1.5 gunta each has been granted in favor of the plaintiffs. Entire property, Malats, entire suit schedule properties have been bequeathed in favor of the defendant, that is the daughter-in-law.
Let's come to the order of the court. Where is the order?
Paragraph 21 of the order, Malats.
Page number.
Page number 20, my lords.
Page 20.
Page 20.
Well, further content, the defendant as filing a present
Only
application.
objection of the plaintiff is
Drag on
the
the-
application is filed to delay the proceedings and to defeat the directions of the High Court. That's the only ground.
Yes, Malats. The only thing is that Malats, the will, Malats, as per section 68, Malats, it is bound in duty on the
No,
defendant,
that's not
propounder
your,
of the will.
That is not your ground at all. You only say this application is filed to
drag the proceedings, Malats.
That's it. That's the only ground.
Malats, one more thing, Malats, kindly refer to the further reading, Malats.
It is also certain that the power is only for the purpose of clarifying any the evidence and not to enable a party to fill up omissions or lacuna. In the present case, the defendants are clearly attempting to reopen the evidence under the guise of recall, which is impermissible. Without assigning any valid convincing reasons that the application for the drag the proceedings. No, why not in one day let the cross-examination be done? What is the prejudice to you? And there is no question of delay in this.
Malats, I agree, Malats, for this reason. Now you want to seek recall of PW1. Malats, PW1, the plaintiff is the Malats have sued for partition. Malats, the defense taken by the defendant is for that she has acquired this property by virtue of the will executed by father-in-law. Malats, now they want.
Maybe she wants to elicit that this will is very much in the notice of the plaintiff.
Yes, my lords, that's what.
Malats, no. Malats, for this reason, Malats, for that, Malats, PW1 has been cross-examined to that effect that under the said will, 1.5 gunta has been, Malats, bequeathed in. Malats, for this reason.
As on the day when your cross-examination was done.
Yes, Malats.
There was no
issue.
The specific issue with regard to this.
Yes, Malats, the part.
Issue is framed at a later stage.
Malats, parties have adduced their evidence based on the pleadings of the parties, Malats. He has cross-examined based on the will itself.
In my view, no prejudice to you.
Malats, I am definitely.
One day we will fix it.
Yes, one day is
and it should be concluded and
yes,
immediately the court shall proceed with the matter.
Yes,
we'll fix a date also for that.
Please.
When is
it? I'll appear tomorrow itself, Malats, because the matter is listed tomorrow.
Tomorrow, yes.
Tomorrow
you cross-examine.
Yes, Malats.
I do it on Monday. Tomorrow I have some difficulty. I need to go for medical.
Huh?
I need to go for a treatment tomorrow.
You are the one who is appearing
yes,
before the trial.
I'm the one who is appearing before the trial. Monday I do it.
Agreed with the orders passed in I number 10. Invoice number 3506 of 2015 dated 29th April 2026 by so and so court. The defendant is before this court. The respondent herein has filed a suit for partition and separate possession that came to be decreed.
Yes,
my lord.
That came to be decreed. Against that, RA is filed.
RFA
is filed. RFA number
My lords,
1940 of
1940 of
2025.
25.
1940 of 2025 before this court.
Yes,
Yes,
my lords.
Before this court, and by
1911.
judgment and decree dated
17 November 2025.
17/11/2025, this court has remanded the matter for the limited purpose with regard to the will. The court has directed the trial court to frame an issue, frame an issue, frame an issue. It is submitted thereafter. The plaintiff stated that he has no evidence, and the defendant has led the evidence. And after the evidence of the defendant, he has filed an application, and they filed the instant application for recalling the PW1 for further cross-examination. It is the case of the plaintiff that, where is that affidavit of yours?
Page number 59.
It is the case of the plaintiff that.
Defendant.
It's a case of the defendant that, since the plaintiff is also a beneficiary to the will produced as Exhibit D5 and D14, and the burden of proving the will is on the defendant based on the issues framed by the court, it's just unnecessary to cross-examine PW1. That was objected by the plaintiff, stating that the High Court has fixed a time frame of 6 months. 6 months?
No, my lords, end of vacation,
summer vacation.
2026.
To complete the exercise before the summer vacation 2026. This application is filed only to protract the proceedings, and no reasons are stated in the application that's filed by the defendant seeking to recall. The court, by order impugned, had dismissed the IA on the ground that the application is filed only to protract the proceedings, and no reasons are stated. Agreed thereby, the defendant is before this court. When counsel appearing for the defendant submits that there is no intention on the part of the defendant to protract the proceedings. In fact, as per the timeline by the court, as per the timeline fixed by the High Court, they've been prosecuting the matter. It is submitted that in the interest of justice and to prove the will, it as he is also a beneficiary, it is very much necessary to cross-examine PW, the plaintiff, and the court on a without appreciating the said fact, only stating that the timeline is fixed by the court and the application is filed protracting the proceedings, as dismissed the application, and then same needs to be set aside. When counsel appearing for the respondent plaintiff submits that the court has rightly dismissed the application as the same is filed only to protract the proceedings, and protract the proceedings, it is submitted that the burden lies on the defendant to prove the will. And in fact, with regard to this, the petitioner was in the earlier round of litigation, the plaintiff was cross-examined, and there is nothing to cross-examine the plaintiff at this juncture, and the same is filed and the court has rightly considered the same and dismissed the application. It's for having read the counsels on either side. There is the material on record. The submission of the learned counsel for the petition, the plaintiff is that the earlier the plaintiff is examined at length, the evidence is written at length, and now at this point of time, as the burden lies on the defendant to prove the will, the further examination of the chief for further cross-examination to recall the PW1 for further cross-examination is not necessary. This court is not able to appreciate the said submission as at the time earlier, whatever the evidence that is written, there was no issue with regard to proving of the alleged will. Now, as an additional issue is framed, if the plaintiff is cross-examined, there is no prejudice to him, and the defendant would be able to elicit. It would facilitate the defendant to prove the will, as he is also the plaintiff is also a beneficiary of the said will in that view of the matter. This court, this court is reviewed that the order that is passed by the court needs to be set aside. At the same time, this court is conscious of the earlier order passed in the R, in a RFA where a timeline is fixed. And considering all this, this court is passing the following order. The order passed by so and so, so and so, and so and so is set aside. Next, number 2, the matter is remanded back to the court, is set aside, and the IA number so and so is allowed. The matter is remanded back to the trial court. And on Monday,
8th.
that's
8th.
on 8th of June, the defendant shall cross-examine the PW1 and he shall conclude it on the same day.
Lords, one more thing. Now it is also posted for further defendant evidence. Lords, let him also lead his
Yes, my lords,
evidence
I am
on the same day, my lords.
And on the same day, he shall
Lords,
cross-examine.
it is for the witness, lords, for that I need to file application for, witness is ready, lords, for the formality I need
Lords,
to
let
file an
them-
application.
my lords, I have no
under Order
objection.
16, that I'll file. Yes, I do, my lords, it is ready. That I
Same day,
do.
my lords, let him examine on the same day, my lords. I have no objection. Today itself, my lords, it may be
Lords,
recorded.
witness, my lords, I have no
Tuesday.
objection to. Witness of the
Monday,
bill,
let
my
him-
lords.
Yes, my
or
lords.
else both Tuesday.
Yes, my lords.
Both Tuesday. Both Tuesday or
My lords,
Monday,
let him
Tuesday.
cross-examination on
That I
Monday.
do, my lords,
That
that I
Tuesday,
do.
my lords, it may be taken.
And on Tuesday, he shall complete his further
Lords,
evidence.
witness has to come. It is
Let
not.
him come.
Yeah, they
because
have to
it's a-
secure, my lords.
Witness of the will, my lords, for will, my lords, we need to summon, my lords. Within 1
This
week I
is
do
nothing
that.
but a dragging the proceedings,
No,
my
my
lords.
lords, within 1 week I do that.
No, then the court, everything
That I
has to
have
be
let my
completed
evidence, my lords, parties have completed their.
by Friday. By Friday, everything has to be completed, whatever you want to do. Friday.
Yes, my lords.
That is 8th, Friday is 12th.
12th.
The defendant's further evidence shall be completed by 12th of June, and the court shall not grant any further adjournments.
Yes,
Shall
only one
proceed-
witness is.
Shall proceed with the matter expeditiously in the light of the orders passed by the High Court.
Please, please.
Much of.
Great.
Number 10, Rakshita DJ.
Here for the petitioner, my lord. In this matter, my lord, we challenge the order of the trial court for awarding the additional award to the respondent, my lord.
For
The
awarding?
awarding the additional amount to the respondent, my lord.
Let's see.
At Annexure A. Petitioner
What is the
is-
additional amount?
Additional amount of 31,125, my lord. The land of the petitioner is 7 number 33, but 33 is measuring of 1 acre 24 guntas, my lord. Out of which the petitioner authority
Acre?
1 acre 24 guntas.
Is acquired.
It's 33 survey number 33 bar 3. It's the land of the respondent. Out of which, my lord, the petitioner authority utilized for the extension of the high tension wire utilizing the respondent land. Out of which 1 acre, we only utilize the 8 guntas, the 35 meters, my lord. If you see, my lord, Annexure C, page 40, the petitioner authority already paid a compensation for the utilization of the respondent land, and the same is accepted by the respondent without any objection. And also, as per the Annexure D, the DC order fixed the compensation accordingly. The authority, after verifying the spot inspection and amount is issued to the petitioner, my lord. Now the trial court has awarded the additional amount of 31,000.
Come to the trial court order.
Annexure A, my lord. Page 14. The operative portion is 32.
The petitioner had grown areca nut and thereby made garden land. The respondent has forcibly drawn so and so or the land of the petitioner. At the time of drawing of the high tension power line, the respondents had destroyed areca nut grown at that time for the purpose of erecting huge tower and drawing high tension electricity lines.
The contention of the petitioner, my lord, at the time of the extension of the high tension wire, the crops is damaged and the demolition value of the property is diminished, my lord. But the respondent have not produced
So
any
one more thing, what
documents.
he's saying is, apart from what you have acquired or what you have, where the lines are laid, because of these lines, high tension lines that are going on, the other remaining property is also of any use to him, is the submission.
Yes, my
Is
lord.
the contention.
Yes, my lord, they have not produced any documents to show there is a
How it is
property.
considered, let's see.
Kindly see at page para 17, my lord. Page 22.
Let's read from the reasoning part.
Yes, ma'am. Para 13, page 20, my lord. Since the 2 points related to each other, so, para 14, the learned counsel for the petitioner argued that the petitioner is the owner of the agriculture land bearing survey number 33/3, measuring 1 acre 24 guntas, situated in so and so, utilizing the land extent of 8 guntas, 8.30 guntas, and have drawn the 66 kV high tension electricity line for the transmitting the electricity installation of tower. Due to the high tension electricity line and agriculture land, it acquires the non-agriculture potential value like commercial value, and the value of the land diminished as such, she is entitled for the seeking compensation amount towards the diminution of the land value for the entire scheduled property. And she led the evidence, my lord, and deposed the petitioner is the owner of the land of survey number 33/3, measuring 1 acre 24 guntas, situated in so and so, Davangere district. In the support of the oral evidence, the petitioner produced the RTC extract of survey number, said survey number as exhibit P1, where it is seen that RTC extract stands in the name of the petitioner. Though the PW1 was cross-examined, the petitioner ownership over the above said land is not disputed. And no doubt that the RTC extract is not a document, the title, since the respondent is not disputing the ownership of the petitioner over the said land, said document is relied upon, and the petitioner along with the RTC extracts of the land also produced at exhibit P2 is the areca nut yield average of a quantity per acre issued by the senior assistant Davangere Horticulture Jilla Panchayat. Exhibit 3 is the GPA and gazette notification. On the other hand, learned counsel to the respondent argued that only 8.30 guntas of the land was utilized for the drawing of the high tension electricity line and for the installation of the tower. Even in spite of the drawing of 66 kV power line on the petitioner remained the owner of the land, and there is no difficulty for her to do the agricultural activities below the line except growing for the long crop. The respondent have already given the crop compensation to the petitioner, and the respondent not acquired the land of the petitioner in accordance with the Land Acquisition Act. Therefore, the title of the land still remained with the petitioner only, since the respondent has already paid the compensation towards the crops, and the petitioner is not entitled to claim any additional compensation amount. Therefore, the submission for the dismissal. For para 18, my lord, is appreciate the regarding the evidence of the both the parties, my lord. The exhibits R1 is the compensation details sum of 52,500 for the land compensation, and exhibit R2 is the DC order. May I read a para?
Come to para 24.
My lord, before that, para 22.
I have seen that.
Even though the petitioner remained the owner of the land, but the petitioner is deprived of the growing the tall trees like areca trees, coconut tree, and tea tree, which is the major crop growing in our lands. Therefore, such deprivation causes the diminution of land value. Also, the petitioner may not be able to sell her land. Since the high tension line is string on the area, therefore, potentially the land will be diminished. But however, the petitioner may cultivate other crops, but the certain growing up other crops may not fetch the other income when the petitioner grows tall trees like areca tree, coconut, and tea tree. My lord, only the contention is they can't further grow the taller trees, my lord. However, my lord, to show the documents, they have not.
Come to para 26.
The principal law laid down by my lordship discussed about the petitioner is entitled for the compensation for the diminution of land value and also for the sustaining the loss of cutting down of the standing trees in the agricultural land. The respondents have not disputed about the facts of drawing the 66 kV high tension wire and huge tower over the petitioner's land. But it's a rival contention that a respondent that petitioner is not entitled for the compensation for the corridor, restricting impose about not using that 35 meters of width and the line passes over the survey number 33/3. Therefore, the dispute is about whether the petitioner is entitled for the compensation for the corridor area and not. It is admitted by the respondent that the petitioner shall not
So
use
what
for
is
the
wrong with this order?
My lord, the thing is, my lord, they have not, they accepted the compensation, my lord, 56,500. And based on the DC order, my lord, after the survey conducting the meeting, they fixed the value of the property in those districts. Till today, the district commissioner order is not challenged by the respondent, my lord. According to the district order, only the authority has issued the
When
compensation.
will they go to the civil court?
My lord,
After the order passed by the
compensation. But the DC order is never accepted. My lord, till today, they have not challenged the DC order, which is for the additional value, my lord, they can challenge the DC order, but they accepted the DC order with fixing the compensation amount per acre. If you see annexed D, my lord, they consider the 100% dimension value and they've taken the fixed the amount, my lord. So it amounts to in a double compensation.
simple amount that is granted 32,000. They
My
no,
lord, for
as per this, they cannot raise areca nut, coconut, and all for that corridor value. Also, they are entitled.
considering all this, my lord, only
But
the
where did you
35
consider?
meters.
Let's see in the DC's order. Where is it considered?
My lord, if DC order is in,
Where is it considered?
its translation is not produced by the land interest.
Oh, I think the other day also some other matter has come up.
It's on 16th, my lord.
Notice to the respondents. This is matter. Give that number. It will come along with that.
Yes.
That day we will dispose of the matters. You please get ready.
Yes.
Only thing is like that should not be the argument saying that DC order they have accepted the amount. No. What is wrong with the civil court's order? Why they are not entitled? That you argue will decide.
Yes.
List along with so and so on 16. Yes.
Cell number 11. Ranjan Kumar K.
For petitioner. Petitioner, my lord, is the owner of the scheduled property having acquired the same, my lord, under a gift deed, under a partition deed, my lord, from his family members. Subsequent to that, my lord, there was a old building existed, my lord, in the.
What is the impugned order?
The impugned order is Annexure A, my lord. May I produce,
the
my lord, the
notice
translated
issued to-
copy of this order? May I?
What is the notice?
The notice, my lord, says that.
Okay, take that.
Yeah, this is the translation copy, my lord. It says, my lord, that to get a power connection, my lord, I need an occupancy certificate now.
We'll do some. We'll issue who appears with this.
Yes. And there is a threat of disconnection, my lord. On my assurance, I have assured them, my lord, that I'll get some order. Therefore, my lord, they have not disconnected till today. Yesterday also they were present.
Who appears?
HV Devaraj.
Ask, inform him. I'll take it up before raising it. I'll take it up at 1 o'clock.
Yes.
Mr. Devraj.
Yes.
Cell number 12. K.
Serve him the paper so that he'll get instructions.
Chandranath Tariga.
Appear for respondent number 1. My lord, this matter pertains to those registration of Bharat stage vehicles.
When is it coming up?
It's coming up on Monday, my lord. It may be clubbed along with that.
List on Monday, along with, give the number.
Petition number 0561.
Cell number 13 for admission matters.
For petitioner, my lord.
Yes.
The respondent herein has filed the suit for declaration of permanent injunction against the petitioner.
Suit for?
Declaration and permanent injunction against the petitioner's dependents here.
On what ground this IA is filed?
IA is Order 7 Rule 11.
On what ground? Let's see your affidavit.
The cause of action does not arise under.
Let's see your affidavit. Where is your affidavit?
IA Annexure H, my lord. Annexure H, my lord.
Page number?
Page number 53 IA.
Let's see.
Order 7 Rule 11A, B and D. The plaintiff does not disclose a cause of action. The suit appears from the statement in the plaintiff to be barred by law of limitation. The suit filed in the pleadings, the response is not mentioned in the pleadings cause of action, my lord. After the 34 years of after 35 years, there by questioning the legality of the sale deeds, my lord. The suit filed on 2015, my lord. Now this IA is filed at the stage of the.
Please come to the order.
Yeah. Can I read? Page number 14, my lord. Next year.
Yes.
There is no cause of action, my lord. There is no date, year, and day. They are not mentioned in the plaint. And barred by limitation, after the lapse of 35 years, they filed the issue taking the petition, madam. Now you.
Come to the plaint. The court has considered this aspect. Come to the plaint. Where is the plaint? So the cause of action for the suit arose yesterday when the defendant, they filed the plaintiff on 7/12/2020. Trespassed into the plaintiff's scheduled property and tried to obstruct the possession of the plaintiff and tried to evict the plaintiff. That's a cause of action. Yes, dismissed. Order will follow. Yes, next.
Civil 14.
Yes.
That this writ petition is filed by the defendant number 6 and 7. That suit is for partition and separate possession filed by the respondent number 1. Other genealogical tree is at page number 2.
Page number?
2, my lord. Running page 2.
Hmm.
Yes, in the synopsis portion.
Hmm.
That Basappa is the original propositus. He had 5 children. Malligamma is the plaintiff, second children.
Hmm.
She said 78 years, at the age of 78 years, she has filed the suit for partition. My lord, the plaintiff.
And where, who are you?
My lord, we are the children of Champa D5, third person, and Chikkamallaya, fourth children. My lord, plaint may kindly be seen at page number 22.
No, first of all, before we see all this, come to your IA in support of.
Yes, sir. Yes. My lord, IA in support for this reason, my lord. Prior in the plaint at page number 22 may kindly be seen. Prior in the plaint at page number
We'll
22.
see that. Let's see the affidavit first.
Yes, please. Para number 3, page number 34. As admitted by the plaintiff, yes. Para number 5 of the plaint, in the ninth line, it is averred that defendant disclosed as they were already partitioned the properties themselves during the year 2000. However, in the said alleged partition, defendants are not at all allotted any share in favor of the plaintiff. Further, in the prior matter for partition and separate portion of the plaintiff's item said in the suit schedule properties by meets and bounds by holding that registered partition deed dated 21/1/2000, which is registered in the office of the sub registrar Sira White so and so so and so. Well, after 24 years of the partition, she registered partition, she has filed a suit for partition at the age of 78. Well, it is covered under the law laid down by the Honorable Supreme Court in case of Inish Sharma versus Rakesh Sharma and others. My partition is saved.
Please come to the impugned order.
Yes. At page number 16, my lord.
Yes.
My lord, finding is at para number 10, page number 17. So only finding is share is not allotted to the plaintiff as she has got right under section 6 of the Hindu Succession Act. She was not a party to the partition. Before amendment was brought into force for section 6, introduction of 6A, the partition was affected. And after 24 years, she has filed the suit for partition, even at the age of 78.
Notice to the respondents. Petition is permitted to.
The respondent number 1 to 4, for 5 to 10, it may be dispensed. They are co-defendants.
Memo is filed seeking dispensation of notice to 5 to
10.
5 to 10. Notice to respondents 1 to 4. When counsel for the petitioner submits that the plaintiff has filed a suit for declaration, suit for partition, stating and also a declaration that the declaration is also sought.
Yes,
that the family partition which has taken place in the year 2000 is not binding on her. It is submitted that the suit itself is not maintainable in the light of section 6 of the section 6
6A, introduction of 6A.
In the light of section 6A of the Hindu Succession Act. It is submitted that this partition which is admitted by her had taken place in the year 2000 is protected by the said amendment, and as such the suit itself is not maintainable. This aspect was not considered by the court. Considering the same, there shall be stay of all further proceedings on the file of so and so so and so. The petitioner shall take out hand summons on respondent number. In addition, the petitioner shall take out hand summons on the counsel appearing for the respondents 1 to 4 and shall file a memo to the effect by 30th of June, or else the stay granted by this court stands vacated. Yes.
List number 2, for admission, serial number 1, Dayal of Paint.
Defendant's revision petition. The court passed the decree, judgment and decree without jurisdiction is a nullity. So by plain averment itself are very clear. Lordship can take your lordship to page number 12, my lord. Judgment. Transfer of property is not applicable. HRC Act is applicable. Karnataka intent. Brief facts averred in the plaint are as follows. The court could have rejected the plaint itself on the face of it at the time and at the commencement
So
of
the
the trial.
plaintiff is partly decreed to quit, vacate, deliver vacant portion of the suit property.
Court has no jurisdiction.
Directed to pay damages of 3,000.
Without jurisdiction, the court has passed an order. I will read. Rent of the premises according to the plaintiff is 3,000. It's a residential. As contemplated under section 3(2) of the Act, rent should be, if it exceeds 3,500, then the TP Act is applicable. Here the rent according to the plaintiff itself, it is 3,000 per month on residential premises. So the court has passed this judgment without jurisdiction.
No, it's a small causes court.
Please, madam.
Small causes court has jurisdiction.
No, small causes court, madam, under the provisions of TP Act, the court has proceeded, not under the Rent Control Act. 3,000 is applicable only where rent under the Rent Control Act only. She has to approve the bona fide requirements. Here the court on the termination of tenancy.
Where do you get that? Whether the plaintiff proves that there is a relationship of landlord. Tenancy
Landlord,
of the
my lord,
defendant has been legally terminated.
my lord, I submit, my lord. The plaintiff and the husband, there is a dispute between plaintiff and husband. Husband inducted the defendant to the premises. That is admitted. I will read the plaintiff amendment at page number 12, please.
Then counts for the petitioner's officer. The court, the rent, as per the plaintiff amendments, the rent is 3,000. And the petition, the court as, the small causes court has jurisdiction to decide the eviction suits and the Rent Control Act, where the rent is 3,000, below 3,500.
Rent should be below 3,500.
The rent should be, when where the rent is below
If it exceeds
3,500.
then the TP Act is applicable.
And the court has the jurisdiction to decide the same under the Rent Control Act.
Section 2.
But whereas in this case, the court has decided where the rent is 3,000. The
2,
court
3
has
G.
decided under the Transfer of Property Act, it is submitted that the court has no jurisdiction to pass such an order. Considering the submission of the learned counsel for the petition, there shall be stay of all further proceeding pursuant to the judgment and decree dated 5th January 2026. Notice to the respondents.
Served, man.
Sir,
Served.
we'll see. Yes, there shall be stay of all further proceeding.
Till number 2.
Interim stay.
Granted.
Granted, sir.
Much.
Ajit CA, Ajit sir, Ajit CA petitioner.
I'm appearing for the petitioner here.
Yes.
The petitioner are the defendants before the trial court, Your Honor. The suit is for the injunction. The plaintiff has filed the suit on the basis of an alleged sale agreement executed by the defendants in his favor.
Executed by the defendant in favor of the plaintiff.
It is alleged by the plaintiff. So he has not sought for the specific performance suit and other money recovery suit. He has filed the suit for injunction. As per section 41
There is
H.
a judgment of one. There is one judgment.
Yes, Your Honor. Recent judgment on
Recent judgment.
recent Supreme Court judgment.
No, how he can protect his possession. In that regard, there is a judgment.
He has to file a specific performance suit. Merely injunction suit is not maintainable, Your Honor. He has to file. Kindly see the.
I'll have this matter on Monday. Because there is a judgment. Somehow I remember I've come across one judgment of the Supreme Court.
Recently in last year,
Let's see
Supreme
that.
Court.
Pass on. Under 53A, part performance of the contract, there is a judgment of the apex court where it has dealt with this kind of a situation.
In this judgment, Your Honor, I have highlighted the respondent not in position and the appellant is settled position over the.
This is a case where he is in possession of the property.
He is not in position.
That's not his case.
Not his case. I
Let's
am
see
in
the
position.
plaint. Let's see the plaint. I'm saying a case in those circumstances. Where is where the position is delivered to the
The agreement is at annexure B,
not
page number
agreement.
26.
Come to the plaint.
At page number 21, annexure B, Your Honor. In page 22, para 3, Your Honor. The plaintiff submit that on 18/10/2021, the defendants entered into an agreement with the plaintiff to sell the susceptible property in favor of the plaintiff for a total sale consideration. And para 5, Your Honor. The plaintiff respectively submits that after the above said sale agreement, the plaintiff has demanded the defendants to secure, collect the proper and correct documents of the scheduled property for
Please come
registration.
to the impugned order.
Yes.
Impugned order, please come to the impugned order.
Impugned order, in page 19, at para 13, Your Honor. Rejected on this ground only. 14, thus applying the law laid down by the Honorable Apex Court in
Then
the
counsel
decision
appearing for the
referred to
petition
supra.
submits that the court has failed to consider the application that is filed under Order 7 to 11. It is submitted that the plaintiff has filed a suit for injunction basing on an agreement of sale. He has not for seeking specific performance of a agreement of sale. It is submitted that there cannot be any injunction against the true owner, and the remedy that is available to the party is to file a specific performance suit. In this case, such suit is not filed. He had relied on the judgment of the Apex Court in correspondence RPANMS Education Institution versus P. Gunashekhar and other, arising out of civil appeal number 5200 of 2025, dated 16th April 2025, and submits that the mere suit for injunction is not maintainable. This aspect was not at all considered by the court, which can be considered basing on the plain averments alone. Considering the same, they shall be stay of all further proceedings in so and so on the file of so and so. The petition is permitted to take out hand summons on the counsel appearing for the respondents and shall file a memo to that effect by 1st of July, or else stay granted by this court stands vacated. Yes, next.
Bill number 3, Bhimappa.
The matter came up on 2/6/2026. As there was no representation on behalf of the petitioner, the matter was directed to be listed for dismissal. Today also, there is no representation on behalf of the petitioner. Accordingly, the CRP is dismissed for non-prosecution.
Bill number 4, Suniti.
This is a writ petition of 2024. And the office objections were not complied with right from 2024 till 2026. And the matter came up before the court for the first time on 26/2026. And on the day, there was no representation on behalf of the petitioner. Considering the same, the matter is directed to be listed under the caption for dismissal. Today also, there is no representation. A writ petition that is filed against an interlocutory order of the year 2024 is kept pending till 2026 without complying with the office objections. That itself shows that the petitioner is not interested to pursue the matter. Accordingly, the writ petition is dismissed for non-prosecution.
Bill number 5, Suresh Kumar S.
So also, same writ petition of 2024 came up on 2/6/2026. Same, this also like the other order. Yes.
Bill number 6, Karthik BY.
For the petitioner in this case, my lords. My lords, in this case is for suit for, I'm challenging an order of police protection granted in a suit for injunction filed by the respondent here in my lords. My lords, the suit is filed on the strength claiming that there is a vacant site in the Gram village, my lords, which I claim that I have the properties, I am the absolute owner, and Kata and mutation are in my favor because I was presiding in that in possession of that particular property since long time, my lord. And considering my long possession, the panchayat has issued me a mutated my name in the register, my lords. Similarly, on the same property, my lords, the plaintiff has got created a document as a Hakupatra or allotment site having to be issued by area
When was
development
the
officer.
injunction granted?
Sorry.
When was the injunction granted? Interim
Injunction is granted, my lord, sir. On 21st December 2019, my lords.
What happened to that?
My lords, I
There's a
challenge this in
penalty.
MA.
It's a judgment and decree. It's a suit for injunction decreed.
Not decreed, my lords. It's an
So
interim
what happened
order.
then? Have you filed?
I have filed a miscellaneous appeal, my lords, and that also thereby the trial court order has been confirmed.
Confirmed. So
Please,
there
my
is an order of injunction. Then for executing it, what is wrong in granting police protection?
My lords, kindly the averments made in the application and the finding of the trial court, kindly it may be looked into, my lords, because my lords, they say that.
Page number?
My lords,
Where is the impugned order?
Page number. Page number is at 128, my lords. Kindly, the averments is maybe looked into, my lords.
Averments in the affidavit.
In the application, affidavit.
Where is that?
Please,
Page number?
my lords, page number 110, my lords, is the application. 111 is the affidavit, my lords. 111 and 112, my lords. Kindly, my lords, I may be permitted to read from para number 3, my lords.
Yes.
I state that after hearing the plaintiff on application for grant of
No,
interim
in
order,
this matter, when is the order passed?
my lords, the order is passed on 10th February 2025, my lords. Please, my lords.
Almost 1 year, 4 months.
My lords, even that application is filed after 1 year of the alleged
No.
incident, my lords.
No, they must have been, it must have been already executed. Already police protection must have given. What remains now?
It's no police protection. Physically, they have come, my lords. It is just on the papers, my lords.
Let it remain in
Please, my
papers
lords.
then. If there is no.
Because, my lords, kindly see the averments, my lords. In that they say
Take out
that
hand summons.
only for.
Take out hand summons, no urgency.
Please, my lords.
The petition is permitted to take out hand summons on the counsel appearing before the trial court for the respondent and shall a memo to that effect by 14th of July. If it is filed, this is matter on 15th. Delete from the caption for dismissal.
Till number 7.
Much obliged, my lords.
Tyagaraja M.
My lord, I have received no objection wakalat only yesterday. It may please to grant 2 weeks time for argument.
2 weeks time to argue the matter, admission matter, you preliminary hearing matter, you want 2 weeks time. We can't grant 2 weeks time.
1 week.
Liz's matter on 17th, no further adjournments. Delete from the caption dismissal.
List number 3 for orders matter. Till number 1. Raghavendra K.
For the petitioner in this case.
Yes, Sanghvi.
Petitioner in this case.
Yes.
Suit for ejectment, my lords. Before the trial court, my lords, the petitioner is the defendant before the trial court, my lords. My lords, immediately after the completion of the examination chief of the plaintiff, my lords, the defendant has filed 2 applications, my lords. One under order 14 rule 5 class 1, read with section 151 of CPC for framing of additional issues, my lords. And another application under 6 rule 17, my lords, for incorporation of 1 paragraph in the written statement, my lords. Your Lordship may kindly come to page number 42, annexure E, my lords. The application filed under order 14 rule 5 class 1, my lords. My lords, in this.
Whether the defendant proved that the court fee paid is not proper.
Not proper. And additional issue number 2 is whether the defendant proves that the suit of the plaintiff is liable to be dismissed for non-joinder of necessary parties. My lords, this same contention I have been taken in the written statement. Your Lordship may kindly come to page number 31 of my written statement, my lords.
30?
31, my lords, annexure C. My lords, I may permitted to read that relevant. First paragraph, my lords. It is submitted that the suit filed by the plaintiff is not maintainable in law and facts. The suit is filed.
When was the original issues framed?
My lords, your lordship may kindly come to.
Date you can give.
I have produced the issues also, my lords. That is date is 16/10/2024, my lords. Lord, page number
When is
50.
this IA filed?
My lords, this is IA filed on 12/3/2025, my lords. My lords, your lordship may kindly come to page number 53, my lords. That is the issues.
No, we'll complete this.
Please.
Your written statement.
You
We'll
are,
complete.
please. I may permitted to read that, my lords. It is submitted that the suit filed by the plaintiff is not maintainable in law and facts. This suit is filed with ulterior motives based on the distortion of facts and suppression of facts. The plaintiff, without any basis, has arraigned this defendant in this case in the given facts and the circumstances of the case. He is not the proper and necessary party to the suit. The suit is liable to be dismissed by the Honorable Court on the ground that the suit is not filed by the proper parties, and there is no cause of action for filing of the suit against this defendant. The suit of the plaintiff is barred by limitation, and the suit is not properly valued by the plaintiff. On this score itself, the suit of the plaintiff is not maintainable and liable to be dismissed. The suit of plaintiff is liable to be dismissed for non-gender of necessary parties.
Who are the necessary parties?
Your lordship may kindly come to the issues framed by the Honorable Court. Before that,
No, you say that there is.
Your lordship may kindly.
You say that you are not a proper party. That
Please.
we can understand.
Not filed by proper parties, my lords. Your lordship may kindly come to plaint, my lords. Plaint, my lords.
I understood that submission.
My lords,
Then there are three submissions.
please.
A party, the person who has filed a suit is not the correct party according to you.
Please, my lords.
Number two, you are not a necessary party to the suit. Number three, who are necessary parties are not impeded. Three contentions are taken.
And
by
court fee, my lords.
For this third contention, what is that you have stated?
Your lordship
The
may
plaintiff.
kindly come. Your lordship may kindly come to plaint, my lords. Plaint. The cause title. Who has filed the suit, my lords? Who has executed the lease agreement and who has filed the suit, my lords?
No, you are the one who is saying that necessary parties are not included or not parties to the suit. Who are the necessary parties?
Necessary party. That's what I am requesting. Your lordship may kindly come to page number 24 of the plaint, my lords. Page number 24 of the plaint, my lords. Page number 24, plaint, my lords. My lords, in that, my lords, cause title, MS Dayalal and Sons, represented by its Karta. My lords, that is measures represented by Karta, my lords. My lords, that has been filed by Mr. Dilip Kumar Dayalal, son of Sri Dayalal. My lords, the lease deed executed by two persons, my lords. The suit has been filed by only one person.
That I understand.
Please, my lords.
Who are the necessary parties? That is what you are
That
saying.
another person who has executed the lease agreement, my lords, he is also proper and necessary parties to the suit, my lords.
Where did you say so?
In the written statement, my lords.
What is that?
Your lordship may kindly come to first paragraph 1, 2, 3, 4, 5, 6, 7, seventh paragraph, my lords. Seventh line, my lords. Sorry. Seventh line of my written statement of first paragraph, my lords. First paragraph, seventh line, my lords. Dismissed by this honorable court on the ground that
Some vague allegation, the suit of the
the suit
plaintiff
is not filed by the proper parties.
That is one. I understood.
Please, my lords.
I'm asking repeatedly about the next one. The suit of the plaintiff is also liable to be dismissed for non-joinder of necessary parties. You don't even say who are the proper parties.
My lords, that another party is also proper party. That is what my respect.
Where did you say so?
That is not filed by that last line, my lords.
And you,
The last line. The
according
suit
to
of the
you,
plaintiff.
according to you, it has to be understood.
No, my lords. Last line it is there. The suit of the plaintiff is also liable to be dismissed for non-joinder of necessary parties to the suit.
Yes, I understood. Yes. Come to the order.
My lords, your lordship may kindly come to another issue, my lords. Court fee.
That I have seen. That I have seen.
Court
Yes.
fee valuation slip has been filed, my lords. He has not properly valued and he has not paid the court fee properly, my lords.
Let's see. Please come to the order.
Orders, impugned order, my lords. Your lordship may kindly come to impugned order, page number 11, my lords. Page number 11. Relevant portion is at page number 17, my lords. Observations. No single observation has been made in respect of this.
17.
17, my lords. Paragraph number 10. That in respect of that additional issues are concerned, that is page number 19, my lords. additional, as far as the additional issues are concerned, the observe these findings given at page number 19, my lords.
And now what you have shown is, where is that, the,
Valuation.
what is the additional pleading you want to take?
That is at page number, my lords, 38, my lords. Page number 38, my lords, annexure D, my lords. Annexure D, my lords. Proposed amendment. It is submitted that the plaintiff has no locus standi to file the above suit for ejectment against the plaintiff, and also the plaintiff is having other commercial premises in the same building and also getting so much of rents from the said commercial
Yes.
premises. And plaintiff is not at all required to the
Yes, I've
social
seen, come to paragraph number 10.
10 minutes. Please, minutes. The finding given on the perusal of the proposed amendment along with the amendments of the written statement. The written statement filed by the defendant consists 12 paragraphs, wherein defendant has already taken his defense, which he is now intending to insert by way of amendment. This could be seen in para number 9 to 11 of the written statement. That is only finding given. Minutes.
No,
There is no
which order you have questioned before this court?
two orders. Minutes.
This is with regard to the amendment.
No, please.
Amendment. Next, come to the next IA.
Next item.
To frame additional
Regarding
issues.
Please, minutes.
Yes,
In that observation, minutes.
I've seen that, yes.
In
Next,
that
order number, IA number 6.
6, minutes. In that, minutes, page number 42. That for the reasons stated in the affidavit.
Number?
Page number 42, minutes.
Oh,
42.
we have seen that the additional two issues.
Two issues, minutes.
Come to the order, come to the order at page.
Order at page number 19, minutes. 19. Order on IA number 6. Para number 2, minutes. Defendant has filed affidavit along with IA number 6, wherein he has sworn
Can
to
come to paragraph number 7 straight away.
7. This suit is filed by the plaintiff against the defendant for the relief of ejectment of defendant from scheduled premises and also for recovery of arrears of rent from defendant to the tune of 16,80,000. According to the plaintiff, he is a landlord and defendant was a tenant by virtue of lease date dated 1/4/2019, which expired on 31/3/2022. As the defendant became defaulter in payment of rent, plaintiff demanded the defendant by issuing notice dated 3/1/2023 and requested the defendant to vacate the scheduled premises. Plaintiff, by issuing a notice on 12/7/2023, determined the tenancy of the defendant under section 106 of the TP Act. As the defendant neither vacated the scheduled premises nor paid the arrears of rent, plaintiff filed the present suit. Defendant filed his written statement denying the arguments of plaintiff and sought for dismissal of the suit. On perusal of the rival pleadings, the only dispute between the parties is that plaintiff and defendant are landlord and tenant, and this defendant being a tenant neither vacated the scheduled premises nor paid arrears of rent. On perusal of IA number 6, defendant has requested the court to frame two additional issues as follows. Additional issue number 1, whether the defendant proves that the court fee paid is not proper. Additional issue number 2, whether the defendant proves that the suit of the plaintiff is liable to be dismissed for non-joinder of necessary parties. Learned counsel for the plaintiff relied on following decisions. So and so, and on next paragraphs. On perusal of the amendments of
I have seen.
on perusal of the amendments of written statement in para 1, he has taken a content.
The order. I have read the order.
Please, Millers. In this, Millers, even I have taken the contentions in the written statement, and on perusal of the entire pleadings, while framing the issues by the trial court, Millers, the trial court has to consider the defense taken by the written statement and pleadings in the plaintiff, Millers, as to be framed issues accordingly, Millers. But you will actually, as far as the valuation slip is concerned, you will actually kindly come to page number 54, Millers. They have not paid proper court fee. They have the suit for ejectment valued as per section 41 subclass 2 of the Karnataka Court Fee and Suit Valuation Act, Millers. Millers, you will also may kindly see the valuation slip, Millers. I have produced the same.
Yes, yes.
Page number 54, Millers.
Yes.
Millers, they have valued total suit for 40,56,000. They have showed the Millers. Millers, they have paid only 1,77,207 under section 21 of the KCF and SV Act, Millers. Well, actually, Act is very clear. They have to pay the court fee according to section 41 subclass 2. They have not paid proper court fee, Millers. For that reason, I have taken that contention. That issue, even if that issue has been framed by the trial court, nothing prevented them to pay the additional court fee or even as far as my additional pleading is concerned in the written statement, my lords, that is not taken away any rights of the plaintiff, my lords. They can file additional objection, additional written statement for that and additional rejoinder for that, my lords.
Last. Yes. Yes.
Please, Your Lordship, first of all, as of today, I am instructed that the rent of nearly 75 lakhs is outstanding. He has neither paid and the landlord is facing.
No, before going into the
Please,
other
please,
merits of
please,
the matter,
Please,
there are two IAs. One is for amendment of the pleadings that I have seen.
please.
As far as that order of the court is correct with regard to the amendment of pleadings. Then coming to the issues, if the issue with regard to the court fees, if it is framed, what is wrong in it? It can be decided by the court. Issue of court
But,
fees, if you're paying a deficit court fees, it is it's a revenue to the.
It is ultimately when the suit is decreed.
No, if there is an issue with regard to it, what is wrong in it? Let there be an issue with regard to the court fees.
That could be.
Yes.
But as far as the amendment is also concerned, my lords, whatever the finding given.
I've seen that.
One.
Yes.
I may permit to make
Yes,
one
yes.
submission, my lords.
Yes.
My lords, as far as the finding given by the trial court, my lords, that is not repeated, my lords. That wrongly came to conclusion by the trial court. That paragraphs, whatever told by the trial court, that has been repeated. No single word has been repeated, my lords. Your Lordship may kindly permit me to.
You made a basis for it. You want to expand it by way of
No,
amendment.
my lords. I have taken different contention in that paragraph.
What is the different contention?
That is not repeated, my lords. My lords, trial court told that is already contained by in the three paragraphs, number 7 to 11. That is not contained the same, my lords. That is no way, that will not change any nature or something else of the suit or pleadings in the written statement, my lords. Only he can file a rejoinder for that, my lords. That will not taken away the rights of the plaintiff, my lords.
Yes.
Only.
Yes, what do you say about the other issue?
Your Lordship, that issue has already been considered. It has been raised. And as the
Which
trial
issue?
court has,
Which issue?
the issue number 1, that is relating to the
Again,
non-joiner of parties. In non-joiner of parties, the point is that there is a registered lease deed represented, it's a HUF. And that the issue is already covered by the series of judgments that any member of the HUF can file a proceedings.
But that issue, it is covered only when the court gives a finding on that.
He's not specific, as the trial court has said, it is not specific. And your Lordship also said that. So now, who is the person according to him who should have filed it? Nothing is mentioned.
Issue, my lords, frame issue.
And asking the court to frame an issue on vague contentions. If I were to take a contention that all the averments in the plate are denied, would that amount to a manner in which the court?
What are the three issues he's asking, 2 or 3? One is with regard to court fees that has to be framed. Then second issue is
non-joiner of
whom to be joined. Where did you say?
My lords, your Lordship, I may permitted to give that lease
Not
agreement.
that. There should be pleadings based
My lords, I
on
have
your
mentioned in the
pleadings.
written statement, my lords. Paragraph number 1.
Mr. Counsel, I have repeatedly asked you and you are only.
I have not mentioned the
you are-
name. That is what your Lordship is asking. My lords.
You just can't say that somebody should be a necessary party. Why? The court will do the
Yes, even my lords,
guesswork.
my lords, even my lords, my respectful submission, my lords, your Lordship may kindly see the prayer in the plaint, my lords. Even that prayer itself is not maintainable. My lords, there is no second defendant in the suit. He stated entire reliefs have been claimed against second defendant. Your Lordship may kindly come to.
Please don't go here and there. When you're making a point, you please take it to a logical end. With regard to this, whom should be the necessary party? You don't say. You say somebody is a necessary party. He is not made party to the suit. That's not
That is
correct.
part and parcel of the document, my lords. That is lease agreement.
It is that's not the way the pleadings will be. That somewhere it is
in the
containing.
pleadings, in the pleadings, my lords, I have stated that suit has been not filed by the proper parties and not filed against the proper and necessary parties. That is what.
For the necessary parties, that you have to state. So that issue is gone. What is the other issue? Only 2 issues.
Only 2 issues.
Yes, as far as court fee is concerned, that then this
Amendment, my lords.
amendment. Now the trial has commenced.
We have led evidence already.
Already and now what by if you look at this amendment, no prejudice to you if
Please,
this is allowed.
I straight away I considered your Lordship. On court fee, your Lordship may proceed.
Not court fee. Amendment of pleadings. What he is asking, he is not introducing any new case, and that is not at all. It won't cause
Taken
any
away the
prejudice to you. So what will we do is that amendment and court fee, both we will allow. And
Subject to deposit of the rent.
no,
I
that-
would,
My
I
lord,
would
my lord.
hold, I
that you
would hold
can
that.
ask the court.
He has already filed the application. I have paid the rents also, my lord.
That is not,
I have-
the part of this.
Please.
Please, please.
Please come. Agreed with orders passed in I number 6 and
Five- 516.
I number 5 and 6 in COM OS number 243 of 2024 dated 14/3/2025. The 14/3/2025. The defendant is before this court. I number 5 is filed under order 6 rule 17 seeking permission to amend the written statement. It is stated that due to oversight, some pleadings were left in the written statement. Hence, it needs to amend the written statement. When it comes to I number 6, he has filed an IA under order 14 rule 5, read section 151 CPC, requesting the court to frame two additional issues. That is, whether the defendant proves that the court fee paid is not proper, whether the defendant proves that the suit of the plaintiff is, why you should prove,
My lord,
why the defendant should prove that the court fee is paid,
plaintiff has to prove.
then why you wanted that
Because
kind
I
of
have
an
taken the
order?
contention, my lord,
Whether the
that-
defendant proves that, you should ask that the issue should be framed. Whether the defendant proves that the suit of the plaintiff is liable to be dismissed for non-joinder of necessary parties. The court, as far as I number 5 is concerned, had dismissed the same. Observing that the court has gone through the proposed amendment to be made in the written statement. On perusal of the proposed amendment, defendant is again contending that plaintiff has no locus standi to file this suit and he is having other commercial premises in the same building and getting rents, and hence plaintiff has no requirement of the scheduled premises. The court has come to the conclusion that the defendant has already taken his defense, which is now intending to insert by way of amendment. This could be seen in para 9 to 11 of the written statement. Hence, the present amendment is not necessary. Then when it comes to the IA number 6, the court has observed that the issues, according to the additional issues to be framed, is whether the defendant proves the court fees paid is correct or not, whether the defendant proves that the suit of the plaintiff is liable to be dismissed. The court has observed that the said framing of issues and casting the burden on the defendant is unknown to the civil jurisprudence. And further, it is observed that basing on the court observed that there are no specific pleadings in the written statement, and basing on the said vague averments, the court cannot frame an issue, and accordingly, both the IAs are dismissed. Next para. When counsel appearing for the petitioner submits that at paragraph number 1 of the plaint, the petitioner has taken a pleading with regard to the proper and necessary parties. And further, the petitioner, by way of an amendment, by seeking amendment of the paras which has to be inserted by way of the amendment are in furtherance to the earlier pleadings, and he has not taken up any new grounds of making out a new case. It is further submitted that it would not cause prejudice to the defendants. Further, it is submitted that the court fee that is paid by the plaintiff is not correct, and the court ought to have considered framed an issue and ought to have considered the same. And even with regard to the proper and necessary parties, also an issue ought to have been framed. The court, in a very hyper-technical manner, without considering the submission of, considering the application and the submission of the council in its proper perspective, had dismissed the IAs. Next para. Learned senior counsel appearing for the petitioner, appearing for the respondent, plaintiff, submits that the petitioner is uh, is uh, is not paying the rents and utilizing the premises, and as of now, an amount of rupees 75 lakhs is due,
Which is including GST.
which including GST is due. It is submitted that the court on both the applications has rightly considered how the basing on the vague amendments or basing on the vague pleadings, no issues can be framed. Further, the uh, even on the amendment application also, court has rightly considered and dismissed the application, and no interference is called for. It is submitted that there may be a direction to the petitioner to pay the arrears of rent, which is running into lakhs. Next part. Having heard the counsels on either side, having gone the counsel for the petition, the learned senior counsel for the respondent, there is a material on record. First coming to I number 5, which is filed for amendment of the pleadings. This court has perused the affidavit that is filed in support of the IA, the amendment that is sought to be introduced in the pleadings, and the finding of the trial court. The finding of the trial court that these pleadings are not taken earlier, are already, they have already taken, and hence it is not necessary and unnecessary in the considered opinion of the court, that cannot be sustained. The perusal of the affidavit and the pleadings, additional pleadings, which the petitioner sought to be introduced by a well amendment, is like the basis is already made in the original pleadings, and the same has been expanded by way of this additional, by way of this IA, where he wants to amend the pleadings. And those pleadings will not cause any prejudice to the plaintiff. And in fact, it would facilitate the court to decide the dispute between the parties in a more, will be able to decide the matter. Next para. Then coming, and as such, in the same para, as such, this court do not find. This court is of view that the order passed on I number 5 needs to be set aside. Then coming to the IA number 6 with regard to the additional issues to be framed. As far as the first issue with regard to the court fee is concerned, when the petitioner has raised a ground, and if the court considers the said issue, and if the court gives a finding on that the court fee as paid by the plaintiff is not correct, he would be paying the same. And why the said issue, why the court has dismissed the same, this court is not able to understand. As far as the second issue is concerned, there are no specific pleadings on behalf of the plaintiff, and the court has rightly held that basing on the vague pleadings, issues cannot be framed. In that view of the matter, this in this, the court says the burden is cast upon the defendant, which is unknown to the civil jurisprudence. In that case, the court can always can frame the issue saying that, within inverted commas, whether the court fee paid by the plaintiff is correct, is sufficient or not. That is that. Whether the court fees paid by the plaintiff is proper or not. Next, in the light of the above discussion, this court is passing the following order. 1, the writ petition is the IA number 6, the order passed by the court in IA number 6, IA number 5 in OS number. So in commercial OS number 243 of 2024, dated so and so by so and so, is set aside, and consequently I number 5 is allowed. Number 2, IA number 6 is partly allowed. And as far as the issue with regard to the court fee is concerned, court shall frame the issue. Court shall frame the issue. Next, accordingly, the writ petition is disposed of.
Some time limit maybe. 27th it's posted, some time limit for amendments and
Suit of which year?
suit of 24 for ejectment, no rent. I don't get the,
Within what time it should be completed?
within a month or two, your
No,
lordship, for him to complete the pleadings.
Generally, what is the time frame?
6 months.
Maximum is 1 year.
Maximum is 1 year.
120
The
days
court
of
shall expeditiously decide the suit.
Much else.
Yes.
Cell
Helpful.
number 2, Siddharth Sumant.
The petitioner, the petitioner before your lordship's my lord is a defendant in a suit. No, my lord, the plaintiff, my lord, is the respondent
I
before.
think the court at the office has raised an
Yes, my
issue.
lord, that office objection, my lord, the office cannot raise, my lord.
What is this
Alternate remedy,
objection?
my lord. Alternate remedy is not a question which the office can raise. It's only for the honorable court to consider.
No, what is the objection?
The objection is the trial court granted an ex parte ad interim order and I filed a writ petition against it. So the office raises an objection to say you should go to that court.
To the, which court has
Or
passed?
it should go to MFA, miscellaneous first appeal. Lord, under Article 227, we are regularly invoking your lordship jurisdiction under 227, my lord, with
No, when you are entitled, when you can file an MA against that.
MFA, my lord, if the order of the lower court is a contested order, then my lord, a miscellaneous, if it's an order under Order 43 Rule 1, appeal will lie to this honorable court as the miscellaneous first appeal. But in this case, the order is an ex parte order. I've got, my lord, other orders of this honorable court where against ex parte orders, 227 writs are entertained. That's the objection, my lord. I'm a bit strange that office raises.
Let's see that order.
Yes.
Where is the order?
The impugned order, my lord, is at page 28. It's a very cryptic order. It has a lot of history behind this litigation. But before I take your lordships through that, please see, my lord. The parties
The
were
matter is posted, call on 2/4/2026.
no, at page number 31,
Yes.
considering the facts and circumstances, right on top.
No, the matter is posted on 2/4/2026.
Yes, it's continued after that.
No, the petitioner can seek for a vacation of that order,
Petitioner, my lord.
can seek for vacating of this order.
No, but I am submitting, my lord, that I am entitled to invoke your lordship's 227 jurisdiction for more than one ground. The first ground is the disputes between these parties were the subject matter of arbitration proceedings. There was an arbitral award passed. I am a developer. He is a landowner. The arbitrator, my lord.
No, only difficulty is now granting an order in this, calling them to come to this court.
Yes.
Instead of that, we'll ask the court to decide your vacate application on the merits of it.
No, that is one easy solution. But what I am submitting, my lord, is this honorable court.
That's not an easy solution. That is a solution where unnecessary delays will not be there.
No, my lord, I submit, my lord, I am supported by authority where such orders which are cryptic, laconic, without reasons, without compliance with Order 39 Rule 3, my lord, immediate interference. Now, please permit me to cite the judgment straight away. Relying on.
There is no dispute about the legal portion on that.
Yeah.
I'm only saying, I can understand the order is passed,
Ex parte order is passed.
Latest order is passed and we can decide it. Now, unnecessarily now granting stay on this
No,
and
my lord,
again calling them
no,
to
my lord,
the.
let this be stayed, my lord, let an expedited hearing, I have no problem. But this order, my lord, I am a developer, my lord, I have 158 flats. My lord, I'll tell you lordship the stark facts of this case. Total decretal amount which is payable to him is 1 crore 50 lakhs something. 153 flats which belong to me as per the arbitral award, they said don't do anything with it, keep it as it is. 1 crore 50 odd lakhs is what is payable to him. He has filed an execution petition. Now, my lord, he ignores all those things, files a separate suit. Now, can a suit filed like this is an issue? My lord, there's an arbitral award, challenge to arbitral award before the Section 34 court, now pending before the High Court. Meanwhile, he files an execution petition. And in the execution petition, my lord, he tries to get an order. I've deposited some money. At this juncture, my lord, just to tie my hands up, he files a separate suit before a court which had no jurisdiction.
What is the suit for?
Your Lordship, the suit is mainly for this injunctive reliefs. He cannot file such a suit at all. Kindly see the prayers in the suit. The order granted at page 31, no reasoning, nothing. Only reason the learned judge gives is, so many application copies are given. May I read, my lord, page 30? The suit is at page, my lord, the plaintiff is at page 32.
No, it is, even the court has looked at the arbitration award also.
Yes, arbitral award is passed. Your Lordship may peruse the arbitral award, my lord. A detailed arbitral award after contest is passed at page 166.
Look at page 30. What is that the court is referring?
No,
One is
not page
arbitration
30.
application.
Yes, my lord. I'll explain that, my lord. He heard peruse the material on record. Arbitration application number 53 of 2018. That was in AC number 164 of 19.
No, here the court is not referring to any of the award.
Nothing. Court has not seen anything just because of
No, these are not awards. Whatever the numbers that are given, they look at it.
AC 164 is the award, ma'am.
Court has seen the award.
It is apparently court has seen it but not read it. That's what I would infer. Because if the learned judge had only seen the award, if your lordship sees the award, my lord, it is there before your lordships.
Which court is this?
At page, the operative portion, lord, is at page
Civil Judge
242.
and JMRC, Devanhalli.
Devanhalli, 242.
Please come.
Then, my lord, not only the award, he filed section 9 application before the court. And parallelly he files this. Section 9, your lordship knows, my lord, can be filed before, during or after the arbitral proceedings. He files a section 9 for enforcement. And that is dismissed. He doesn't challenge it. Then he comes in a separate suit.
Please come. The senior counsel appearing for the petitioner suppress that. The respondent herein has filed a suit for injunction and sought for an ex parte interim injunction. The court without giving any finding with regard to the prima facie case, balance of convenience and irreparable loss, has granted injunction. It is submitted that there was an arbitration between the parties and an award was passed and the same is questioned. It is pending before this court.
Commercial appeal is pending before this honorable court.
That's what the,
Yes.
The appeal is pending before this court. For this court, it is submitted that even the section 9 application that is filed by the plaintiff was dismissed, and even the order impugned before the court. In the order impugned, the court has observed that the plaintiff has produced copies of the development agreement, copies of the orders in arbitration application number 53 of 2018, AC number 164 of 2019, COMAP number 87 of 2021, execution petition number 82 of 2022, AA number 53 of 2022, and WP number 16770 of 2024. When the senior counsel suppressed that, court having perused the said the orders, still granted the injunction. It is submitted, the suit itself is not maintainable, and the court in this manner cannot grant injunction. Hence, the petitioner is come before this court, though there is a remedy to file an appeal against this order. Considering the submission of the learned senior counsel, they shall be stay of all further proceedings pursuant to the order. There shall be stay of operation of the order dated 22/24/2026. Notice to the respondents. The petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by.
The order is dated, my lord, 16/2, my lord.
It's not 2, 16/2.
16.
16/2.
Please.
2026. The
Next reading.
petition shall take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 2nd of July. If the memo is not filed, the stay granted by this court stands vacated.
Three.
I appear for petitioner, my lords. My lords, there is one.
Yes, it is switched off. Yes.
My lords, there is one more writ petition pending before this court, my lords, maybe tagged along with
No,
this
no,
matter.
office objection with regard to the maintainability is overruled. Yes.
There is one more writ petition pending before this honorable court, my lords, maybe tagged along with this matter, my lords.
First of all, you don't pay the process.
My lords, I have taken steps, my lords, and
You appear for?
I appear for respondent number 1 and 2. My lords,
What
that
about
writ petition is preferred by respondent number 3 itself. So
Oh.
therefore,
post along with so and so?
my lords, there is a grave urgency because, my lords, I am the decree holder. They have challenged the jurisdiction of the execution court. They say that it does not come under the commercial court. Now, my lords, I am here to recover.
Matter can't be independently argued.
My lords?
This matter can't be argued independently without that petition.
No, my lords, that same order has been challenged by them also. So therefore, my lords,
Along with so and so on 11th of June.
please, oblige.
Yes.
Say number four.
Respondent, my lord. The last date of hearing, the
What
coordinate.
is the affidavit?
The coordinate bench has directed me to file affidavit.
Respect of residual properties or concerned parties are directed not to create any third party interest in respect of residual property. Residential house is concerned, the defendants are permitted to give it as a mortgage for obtaining the loan. The defendants are unsuccessful in the suit.
Not alienated
No
order.
liability will be on the plaintiff. Only any loan obtained by the defendant in respect of the file affidavit by 30.
I filed the affidavit.
Same for the respondent, my lord.
Basing on this,
This is a
your,
suit for partition, my lord. Order passed by the trial court and
You have seen
appellate court
the-
for not to alienate the order, it is there.
No, no, what I'm asking is, an order is passed on 28/4/2026. Interim order.
Yes, my lord.
Uh,
Yes, my lord, I
In
know.
the light of this, it can be disposed of with the affidavit.
Ma'am,
Yes,
Please.
give that affidavit. Where is that affidavit?
Affidavit, my lords, on 29th April I filed. my lords.
Affidavit you have filed already.
On the counter I filed. my lords. I may be permitted to hand over office.
No, 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 it's there.
Yes, there are two entries.
Please come. The present petition is filed by the defendant number,
Unless all the defendants.
by the defendants agreed with the order dated 13/3/2026, passed by the third Asian District Judge, Shimoga. Where is that order?
Plus annexure case, page number 72, my lords. 72.
By virtue of the order impugned,
'82 is operative question.
what is the order?
My lords, initially, the trial court rejected.
Trial court is rejected for,
Temporary
appellate court
injunction,
is
your lords.
rejected for the temporary injunction. ma'am. I am for the plaintiff before the trial court.
Where is the order in the IA? IA.
Page number 54, my lords. Annexure H, my lords.
54.
Interim order passed.
The trial-
It is filed for partition.
Yes, my lord. Interim order passed by the
Defendant,
trial.
the plaintiff has filed an IA seeking injunction restraining the
Not to
defendants from I number 7 and 8 are filed seeking injunction restraining the defendants, alienating the suit schedule property till the disposal of the suit. I number 7 is pertaining to suit.
Same, my lords. She filed two IS, my lords.
So properties probably 7 and 8.
Same, my lord, same properties.
Why 2 IAs then?
She filed, one is for not to encumber, my lords, another one is for not to alienate, my lords.
The court has allowed both the IAs. Against that, the matter was carried where is that? That order is?
The appeal is also confirmed the order.
A number, and that, that was carried in MA 25 of 2025. And that was, and by order impugned dated 13th March 2026, the appellate court
Modified the order, my lords.
has modified the order, allowed the appeal in part. Where, as far as the order passed on IA number 7 and 8 is confirmed in respect of A and B scheduled properties.
B and C.
The order passed in respect of C scheduled properties is set aside. Against that, the defendants are before this court. A coordinate bench of this court had passed an order on 28/4/2026, extract the order. And as per the order passed by the coordinate bench, an affidavit is filed before this court. Paragraph number 2 and 3 of the affidavit reads thus, extract. Land counsel appearing for both the, appearing on behalf of both the parties submits that in the light of the affidavit and in the light of the earlier arrangement made by this court, the writ petition may be disposed of.
Here the interim order, my lord, related to the defendants of unsuccessful the suit, no liability will to the plaintiff on any loan obtained by the in respect of A schedule property.
That is said so in the affidavit also.
Yes, yes. Allah, order portion of the interim order may kindly. That is in that if the defendants are unsuccessful in the suit, no liability will be on plaintiff on any loan obtained by the defendant in respect of A schedule property. That para will be considered.
That para?
That order, portion of the order also consider in the.
In the final. That's what, in the light of this, this is accordingly that is modified to this.
Please.
That's what I'll observe.
Please.
Accordingly, what did you write? This court is passed the following order. The writ petition is disposed of by modifying the order passed in MA number so and so, whereby the defendants are directed not to create any third party rights in respect of B and C scheduled properties. In respect of A scheduled property, the defendants are permitted to give it as a mortgage for obtaining the loan. Further, if the defendants are unsuccessful in the suit, no liability will be on the plaintiff on any loan obtained by the defendant in respect of A scheduled properties. Accordingly, the writ petition is disposed of.
5 Fayasa PG.
Here for petition, seeking for a 2 days accommodation to do the needful, my lord.
The process, you have an interim order?
No, my lord, that first time that in the vacation.
No, the process shall be, needful shall be done within a period of 2 days, or else the writ petition shall be done by Tuesday, or else the writ petition shall stand dismissed without further reference to the court. E6.
In the meantime, Lord, permit me to serve the copy to the counsel appearing before the trial court. Lord.
Then in that case, that it would have been done long back. Isn't
The
it?
last occasion, what happened, Lord?
Instead of paying this, then counsel for the petition is permitted to take out hand summons and the counsel appearing for the respondent before the trial court. And shall file a memo to that effect by 17 June. If the memo is filed, list the matter on 18.
Much obliged.
Yes, next.
6 Usha Devi KG.
Appearing for the petitioners, my lord. Regarding the objection number 3, they were not yet filed in objections, my lord.
An extra to be stated at prayer. That can be done.
During
Jurisdiction to be
course of the day, I
stated
will
at cause title.
During course of the day, I will do.
Objections to IA to be filed.
That objection was not yet been filed by the.
Office objections 1 and 2 shall be complied with within 2 days.
Today itself, during course of the day, I will do
During the
it.
course of the day, Objection 1 and 2 shall be complied with. Objection 3, it is submitted by the land council that no objections are filed to the IA. The submission is taken on record and the objection number 3 is overruled. Yes.
Regarding this, the two application has been filed by me, my lord. One is recalling and reopening of crash of PW1.
What is the suit for?
Suit for specific performance, my lord.
Which year is the suit?
My lord?
Year.
2018, my lord.
When was the evidence closed?
1.5 years back, my lord. The order was passed by the trial court after the lapse of 1.5 years. Hence, the application has been rejected. That's
Where is your IA?
page number 36, my lord.
30?
36. Annexure C, my lord.
You said the suit is for specific performance.
Specific performance, my lord.
Out of station means where are you?
He was in out of station, my lord.
Where were you? Where is the court and where are you? Where were you for 6 months?
He was in out of station, my lord. The client was not yet instructed me regarding this.
On those grounds, will there be an application like this?
It will cause us to justice to my lord. I request.
And why did you wait till 1.5 years to file this IA? Okay, we'll accept that you couldn't. 6 months. 6 months you were out of station. Wherever station, we don't know. So you are out of station. Then what happened thereafter for another 1 year?
The trial court instructed, the trial court advocate was instructed me for the same. He was in out of station. He was unable to contact the client
That's what
itself.
we'll accept, that you're out of station 1 year for 6 months. You were out of station, you couldn't contact him. This application is filed after with a delay of 1.5 years.
Yes, my lord.
So another 1 year, where were you? At least you have to make out something in your affidavit. That's a whole reason for filing of an affidavit in support of an IA. With all these kind of vague governments, how will the court permit? Let's please come to the order. Where is the
So
order?
the sufficient time is granted.
Page number.
Page number 44, my lord.
Yes.
Second paragraph. Though the sufficient time is granted, the defendants not pleaded the defense evidence. Defendant ends the praise is rejected. The defendant evidence is taken as nil. The plaintiff prays time. The perusal of the truth. The sufficient time is granted. The PW1 is not crashed and the crash examination has taken as nil. After the lapse of 1.5 years, the IA is filed. Hence the appear and the said IA is filed without a genuine reason in the interest. So the application has been rejected.
Correct. Because we can't.
Hardship will be caused.
What hardship? You are a hardship, you should understand. A litigant who is not vigilant, court will not come to their rescue. At least proper reasoning why you are not coming. Nothing has been stated. Agreed with order dated 3/3/2026, passed invoice number 399 of 2018. The defendant is before this court. Then counsel appearing for the petitioner. Defendant submits that as the defendant is out of station for 6 months, the court has taken the defendant's evidence as nil and posted the matter. It is submitted that as for his personal reasons, he was not in station and he could not instruct the advocate. And if the applications are not allowed, it would cause a lot of prejudice to the petitioner, defendant. These aspects were not considered by the court. Having heard the counsel for the petitioner, defendant, peruse the material on record. After this court has perused the affidavit that is filed in support of the application. it is stated that he was out of station for 6 months. This application is filed after 1.5 years. In the affidavit, absolutely there is no reason for the latches on the part of the petitioner. It is a submission that if this application is not allowed, it would cause lot of prejudice. The courts cannot come to the rescue of a litigant who is not vigilant in prosecuting the matter. Considering that there are no reasons stated in the affidavit, nor it is nor even in the submissions made today, why it was not filed at an earliest point of time was not stated, considering the fact that this is suit of 2018 and this court is not, and the reason that was stated by the court, court do not require any interference accordingly dismissed.
Number 7. Abhinav Anand.
Yes.
Lord, I've made submissions with regard to compliance of office objections.
What
2
are
and
these
3.
office objections?
So, office objection number 2, my lord, that single WP is filed challenging more than 2 IAs. I am not seeking any orders for quashing the IAs, orders passed on IAs, more than 1. I am just praying this honorable court to direct the trial court to pass orders on IA number 1 and IA number 5.
Office objections are overruled. Yes. When did you file the IA?
IA.
When did you file?
It was filed in December, my lord.
IFR?
16th December 25. So
IFR?
far, no orders has been passed.
IFR?
IA 1, that is under orders 39 rules 1 and 2.
Please come.
CPC.
The present writ petition is filed, seeking a mandamus directing the first additional senior judge and JMFC Ramanagara to consider the IA number 1 and IA number 2.
IA number 5.
IA number 1 and 5.
1 and 5.
IA number 1 and 5, which are pending before the court from the month of December. When counsel for the petitioner submits that they have filed application seeking injunction that are pending before the court right from the December, that is almost from the last more than 7 months, and the same was not considered by the court. Next, considering the submission of the learned counsel for the petitioner and the fact that these applications are pending from the last from December 2025, this court is passing the following order. The writ petition is disposed of directing the so and so dispose of I number 1 and I number 5 as expeditiously as possible. Both are for injunction.
One is for injunction, another is for impleading of the
For
GB.
application, which is for injunction.
IA number 1.
Application shall be considered expeditiously. I number 1 shall be considered within a period of 1 month from the date of receipt of the copy of the order. Shall be disposed of within a period of 1 month from the date of receipt of the copy of the order.
In the meantime, defendants 1 to 17 may kindly be restrained from drawing
No,
conclusions.
no, that kind of orders can't be passed. And this court is not issuing any notice to the respondent as no adverse orders are passed. Yes.
Cell number 8. Minto Isaac.
Petitioner, my lord. It is at the stage of a notice, my lord. We have issued the notice 3 times. Every time it has been returned. We have issued the notice to the address.
What is this IA?
It's for paper publication, my lord.
No. What is the impugned IA?
Impugned is for the taking a steps through.
Impugned order.
Our prayer was to quash the orders passed by the seniors here. I'm not able to understand my lord's question, my lord.
Order 7 to 11. Then the suit must be pending. Why don't you take the hand summons on the counsel for the respondent?
I'll do that, my lord.
That's better. The petition shall take out hand summons on the counsel appearing for the respondent to the trial court and shall file a memo to that effect by 2nd of July, or else the writ petition shall stand dismissed without further reference to the court.
Obliged.
Yes,
Cell
next.
number 9. Rachana Bharadwaj.
May it please your lordship.
Yes.
Lord, there's a delay. Application is filed seeking condonation. This is the second round of litigation I'm coming. Earlier, the petitioner had filed a writ petition under Article 227, questioning the order of the trial court. This honorable court, while granting an.
You're ready?
My lords, I am for the respondent. I will file my objections to condonation as well as the application that was served upon me yesterday.
When did you enter appearance?
No notice is ordered in this.
What had happened is, my lords, the WP, the writ petition came to be converted into a CRP. I had entered appearance in the writ petition. Therefore, my name was shown. They have filed an application under 39(1) and 2 day before, and I was served upon it day before. I'll file my objections to the same. What has happened is, my lords, there's been a delay even after if your lordships would see the first order in the writ petition.
So are you arguing on the merits?
I'm just bringing some facts to the.
Let me make my submissions. It's my application.
Very well. Then I'll file my objections. Let a date be fixed, my lords.
When will you file?
Well, it's next week, my lords. Any date.
I'll take it up on Tuesday.
Obliged.
May I request for 11th, my lords? 11th, Thursday.
11th.
No, 11th. No, I have some difficulty on 11th. Could it be on 12th?
Great.
Obliged.
Cell number 10. Cell number 10. M. Sudhakar Pai.
Petitioner, my lord, arising out of an order on interlocutory application and regular appeal. My lord, fact scenario, my lord, of this case is, I have paid the entire consideration of the residential flat, put in possession.
What is the suit for?
The suit is one for ejectment, one is for specific performance. There are two suits. Filed by me is for specific performance, filed by them for ejectment after putting me in possession, obtaining the entire sale consideration. They have obtained the entire sale consideration. It is a residential condominium, my lord, constructed by the church for the needy people of the community, Christian community. Around that year, my lord, 1,30,000 was the total sale consideration. I have paid it. I put in possession. They, my lord, kept the process of executing the sale deed in my favor. In the meantime, my lord, they filed a suit for possession against me in respect to the very same flat. I filed a suit for specific performance. Now, your lordship may kindly see, my lord, Annexure A.
Yes.
It is their suit for possession. This is dismissed, my lord, on 4th May 2020. 4 May 2020, Annexure A, my lord. Now, your lordship may kindly.
And what happened to your specific performance? Sir?
My specific performance is also dismissed, reversed in appeal. It has attained finality. Against that, there is no second appeal. Their suit for possession is also dismissed, against which, my lord, they filed a regular appeal RA 23 of 2020. So, my specific performance is also dismissed by the trial court, allowed by the first appellate court, which is not challenged by them. My lord, as of now, it has attained finality. It is an undisputed fact. Now, my lord, I filed an execution for effecting the sale deed. So I made an application before the first appellate court in their RA to defer the proceedings in RA pending, my lord, decision in my execution. Now only a formality, my lord. Anyhow, my lord, now I am in a position by virtue of my RA being allowed, I have become the owner. Only sale deed is to be executed. Now, your lordship may kindly, my lord, Annexure B, my lord, is their regular appeal against dismissal of their suit for possession.
When was it dismissed? It was dismissed on 4th May 2020.
Which one, my lord?
Their suit for possession.
Their suit for possession was dismissed on 4th May 2020.
When was the appeal filed?
Appeal, my lord, they have filed immediately in, I will submit. 7/8/2020, my lord. Now, your lordship may kindly see, my lord, Annexure C, ink page 41, my lord. It is my RA against dismissal of my suit for specific performance. RA 7 of 2016, my lord, which is allowed on 4th December 2021. my suit, my regular appeal as against the dismissal of suit for specific performance is allowed.
Yes.
And this has attained finality. There is no dispute about this. RA. My lord, your lordship may kindly turn to ink page 42, my lord. That is the operative portion. 4, page 42, after decree, my lord.
Yes.
That the defendants are directed to execute the registered sale deed within 60 days as per the oral contract and as per the existing amendment deed of declaration filed under the provisions of the Karnataka Apartment Owners Act, failing which the plaintiff is entitled to get the sale deed through the process of court. Now, my lord, the execution is already levied. Annexure D may kindly be perused, my lord.
Yes.
In 2025, my lord, I filed the execution.
Come to the impugned order.
Yes. The IA 3, my lord, my lord, annexure E I filed. But to defer the RE, my lord. Now, impugned order on IA 3, my lord. Your lordship may straight away, my lord, turn to
Page number.
ink page 59, my lord.
Yes.
Heard both sides, peruse the material placed on record. The counsel for the respondent contended that there was an oral agreement between the owner of the suit property and respondent is the prospective purchaser agreeing to transfer one residential apartment in her favor for value received. Subsequently, the appellant constructed the residential condominium and had delivered possession of the promised apartment to her. However, due to legal hitches, the sale deed was not executed. That they amended the earlier registered deed of declaration so and so. Next paragraph. The appellant filed OS number 143 of 2004 on the file of so and so, seeking recovery of possession. She is a permissive occupant and so and so. That in OS number 1 for the respondent filed an application for stay of the trial. Accordingly, the suit had been stayed. That in OS 96 of 2009 filed by the respondent seeking specific performance came to be dismissed on so and so. Thereafter, recording the comments so and so. That after dismissal of so and so, she had preferred RA 7 of 2016 and the same came to be allowed and the appellant has not challenged the said judgment. That the respondent has filed execution petition number so and so on the file of so and so seeking execution and registration of the sale deed. Notice has been ordered to the appellant in the execution case that the one sale deed is executed by the appellant in her favor as per so and so. The present appeal becomes infructuous. Hence, pray to stay the hearing of this appeal till the disposal of the execution petition number so and so on the file of second additional senior civil judge Mangalore.
Come to page paragraph number 10.
Paragraph
10.
That in execution proceedings, the final result would have to have the sale deed in favor of the respondent. The question in the present suit is still the sale deed is obtained by the respondent, whether she is liable to mean profits till she obtains valid sale deed and in possession of the pursuance of the sale deed. Besides this, earlier as per law laid down by the High Court, suit for possession requires to be stayed till the disposal of the specific performance. Now the said proposition of law is overruled. That the order sheet clearly discloses that after the arguments, the respondent, instead of arguing the matter, filed one after another application to drag on the proceedings. That various allegations made in the affidavit by the respondent are frivolous and vexatious. That inherent powers of the court cannot be specific provisions of law. The court cannot exercise inherent powers to stay the proceedings of the appeal on the pretext of belated execution proceedings. That no grounds are made out to stay the further hearing on merits. That great hardship will be caused to the respondent if the application is allowed. On the other hand, no hardship will be caused to the respondent if the application is dismissed. Therefore, he prayed to reject the application with the exemplary cost. Having heard both sides and on perusal the material placed on records, this appeal is filed by the plaintiff appellant aggrieved by the judgment and decree so and so where the relief of possession was not granted. It is admitted by both the parties that the respondent has also filed suit for specific performance in OS so and so during the pendency of the suit under appeal. The trial court stayed so and so till the disposal of. Thereafter, both the suits came to be dismissed. Against the judgment in OS, REA was filed, which came to be allowed by setting aside that the defendants herein are directed to execute the sale deed, registered sale deed, so within 60 days as per which I read to your lordship. The present appeal is filed aggrieved by the judgment passed in suit for possession. Next, my lord, I need not trouble.
I have seen.
Yes.
What do you say?
Your Lordship, the possession was obtained as a licensee, permissive occupant. As on date, she continues to be a permissive occupant. There is a judgment by this honorable court, which I have produced, when the tenant enters the possession,
What if your submission should not be on the merits of the matter?
yes,
What is the application that is filed seeking stay of the suit?
stay of the suit.
That
It
is
is my
permissible or
submission.
not? That's it.
It is my submission, even if till the sale deed is executed, I have a right to recover the possession as held by this honorable court. Further, even if the sale deed is executed in his favor, I have a right to recover the rent till the date the sale deed.
Third reserve. Yes, next.
Allowed.
Yes.
My
11.
lord, one more submission. The application is filed under 151, not under section 10.
Appearing for the
Yes.
petition. What is this? Writ petition is, my lord, rejection of an application for restoration of power connection.
You have an interim order.
I have an interim order.
Where are the respondents? No representation on behalf of the respondents. Interim order earlier granted is extended. Lives this matter in the month of August. Yes, next.
Cell number 12. Chandranath Ariga.
Appear for the petitioner.
Yes.
My lord, the suit petitioner is the defendant in a suit for permanent injunction.
Yes.
My lord, the plaintiff, that is the respondent herein claim that there is already a decree in his favor and decree was put into execution. And in the execution, the possession was handed over to him. That is his case. My lord, the defendant, that is myself, I have filed the return
Both the
state.
courts have held against you.
My lord,
Injunction was rejected by both the courts.
yeah. My lord, their cases, they were put in possession. After that, I am trying to disturb their possession. Therefore, they sought for permanent injunction. My case is out of the land of 1.57 acres, that is the suit schedule property, which my lord finds it at page number 16, 1.2C, 1.57 acres. I was granted with the 80 cents of land and I am in possession of the property. Then I filed the counterclaim for declaring me as the absolute owner of the property to the extent of 80 cents, 80 cents, and also sought for permanent injunction. Now, the boundary of my 80 cents and 80 cents, which I say that it is in 1.57, my lord, that would be, that can be clarified at page 23, paragraph 20 of the 20 minute, annexure B, written statement.
You sought for appointment of advocate commission.
Yes, my lord. Sought for appointment
Let's see the order. What did the court say?
Yes, obliged, my lord. Okay. Annexure E, which begins at page 34.
You can
Page-
come to, you can come
Reasons,
to
reasons,
eight.
yes. The defendant has filed this application seeking to appoint any advocate as court commissioner so as to survey and identify the counterclaim schedule property with the help of a qualified surveyor from the office of ADLR Tashildar Madikeri and note the nature of said property and nature of balance area of 1.2 C in possession of plaintiff with such details of crops and plants grown therein and existence of fence, and also compare the nature of plants and crops on eastern side of the counterclaim schedule property. The defendant has stated in the application that he filed counterclaim myself in respect of counterclaim schedule property seeking adverse possession of land against the plaintiff. Hence, prays to appoint a court commissioner. My lord, this is not fully correct application. I will just point out, my lord, to inspect and report the same for final education. Per contra, the counsel for plaintiff has objected the application and stated that the plaintiff got an order of temporary injunction from this court and the order is still surviving. The defendant is trying to collect the evidence and the application evidence therefore prays to dismiss the application. During the arguments on application, the counsel for defendant furnished two citations, ILR 2001, page 5013, and another, wherein it is held, in view of the matter, the appointment of the commission for measurement of the property and to demarcate the boundaries and correct extent of the properties as per the claims made by the parties would be fully justified. ILR 2023 page so and so, wherein it is held, the trial court shall appoint the
So
jurisdictional.
now your applications for injunction are pending, both applications filed by the plaintiff and the defendant.
Yes,
And
that
now
is.
in the meantime, according to you, the commission should be appointed and it has to be measured.
Yes, to identify that 80 cents, which is in his, he says 1.5. No reasons are given in this application, therefore.
That may kindly see the written statement counterclaim error. Page number 25. Declaring that the defendant is the absolute owner of the property described in the schedule here 2 as defendant having perfected the title by adverse possession. So he is not claiming his absolute title over the property, he is claiming, so he is admitted that I am the owner of the property, my lord. Therefore, question of he is seeking any, and the application filed by him for injunction against me was rejected. And the application filed by me for injunction against the defendant is allowed.
No, that is after this order.
No, come on the same day.
That's
On the same.
No, as on that, what the court observes is.
Because I am in possession.
Both IAs are pending as on. If you look at the order, court says both IAs are pending.
No, along that vacating application, I have produced a copy of the orders passed in on IA number. So the question of now, I can understand, my lord, if the defendant is claiming his absolute right, then question of overlapping or encroachment will arise. Now he is not claiming his absolute right, and his claim is by adverse possession. So the court has considered that there is no material produced by him to show that he is in adverse possession. That is the finding of the trial court in the impugned order, saying that he has not produced any material document to show that he is in adverse.
My lord, my title is also a portion of it is granted to me. Kindly see page 23, paragraph 21, my lord. Para 21. May I read, my lord?
Yes.
The defendant submits.
Yes.
This also stated in the defendant submits that she so and so, his brother so and so, and their sister so and so, and her children, including the plaintiff, are the absolute owners of the property described in the schedule here too. The defendant was cultivating an area of 1.50 acres in government property bearing survey number 1.2D of Nidgune village with the coffee and pepper. This property is towards the east of the property described in the schedule here too. Later, defendant applied for regularization of the said property to him, and he was granted the same by government under Sagwali chit dated 35/80/1998. When the above people were the owners of the property described in the schedule here too, the defendant on 1/6/1990 entered into the possession of the property described in the schedule here too, ousting the said so and so, and her children, including the plaintiff, and adversely to the interest of the said true owners, and fence the same, covering the property described in the schedule here too with this aforesaid property under survey number 1.2D. So therefore 1.2D is the Lakti of 1/2C, 1/2C, and in that 80 cents is included, which is to be, they say, has to be clarified by the surveyor, and the application may kindly be seen for a minute. In the application at page C, as stated, the petitioner above named prays that for the reason stated so and so, the property to survey and identify the counterclaim schedule property, and note the nature of said property and nature of balance of area in survey number 1.1/2C in possession of plaintiff with such details. My lord, there is a judgment. A court is well aware of that Shadakshapa judgment. Nevertheless, please permit me to read. Yes.
Yes.
Paragraph 20, my lord.
Yes.
Paragraph 20, the power of the court to appoint a commissioner for local inspection or any other purpose provided under Article 26 of the code is discretionary. However, the said discretion is guided by not only under Article 26 Rule 9 and 10, but also the provisions of the Act. Then, my lord, I will come to the particular. My lord, paragraph 21 may kindly be seen.
Yes.
Having examined the provisions referred to above and given the fact that Article 26 of the Code of Civil Procedure is often invoked in the trial court, this court is of the view, broadly speaking, in the following cases, the appointment of an appropriate commissioner as provided under Article 26 of the code is desirable. The dispute relating to the easement of air, light, pathway, road, watercourse, etc. The dispute relating to the boundary and encroachment. The dispute relating to forgery. My lord, then the dispute relating to the existence or otherwise of a stream, pond, drainage, etc. The examples given above are not exhaustive, but merely illustrative. The guidelines in this order should not be construed as having exhaustively listed the cases in which the commissioner can be appointed, nor the observation should be construed as having diluted or expanded the discretion vested with the trial court in such matters. My lord, here is a case where that C and D is not bifurcated. I have said that it is D is granted and 80 cents. That 80 cents is in 1.57 of 2C. Where is that demarcation? The surveyor would be able to, because one is granted. I am in possession. And I say that if in that 1.57, my 80 cents is I am in possession. It's a long possession. Maybe because of that, I am entitled for a declaration of adverse possession. All that is a later stage. Now, to find out the measurement or the boundary, this paragraph 21 2, dispute relating to the boundary and encroachment, appointment of ADLR is necessary. Therefore, I am before this honorable court. Court may.
Dismissed. Order will follow.
My survey number is 1/2C. Their claim is 1D.
Yes, yes, yes.
Cell number 13, preliminary hearing.
But your lordships may recollect, my lords, this is the matter where
Seek for a passover, please, my lords. Arguing counsel is on legs in another court. It may kindly be taken up at 2:30, please.
Not possible today, Passover.
lords, I have no difficulty. Could it be taken up on, my lords, the difficulty is this for us. Despite there being an earlier order of this honorable court, when the arbitration suit was pending, this honorable court, the coordinate bench said 4 apartments is sufficient to satisfy the decree. So instead of 4, we are giving 5. So 5 was sufficient.
Is this the matter which has come
This is the
up?
matter. My lords, the difficulty for us is, I have
You
no,
said you'll file an affidavit today.
we are filing now this affidavit. I have already served the,
Copy of it?
yes.
I'll take it up on Monday.
Monday, my lords,
top of
because
the list.
please,
This is matter on the top of the list on Monday, so that
So
I'll
great.
pass orders.
Grateful. Cell number 14, 15 adjourned. Cell number 16, preliminary hearing be group.
Yes.
Petition.
Why 2024 matter is moved by way of a memo?
Lord, this is a final decree proceedings, my lord. After a prolonged litigation, my lord, a decree has been obtained. Now we have filed final decree proceedings. We are out of possession to take our share. Then a separate suit has been filed and that final decree proceedings has been stayed. That is why, my lord, I have been struggling, my lord, for the last several years. My lord, we are out
This
of
will
possession.
require some hearing, my lord. Your lordship may have it on Monday. We will come prepared.
It requires some hearing because apparently my submission is a fraud.
Just on Wednesday.
There are 3 different decrees,
Yes.
compromises.
Yes.
Wednesday.
It's actually
Not
complicated.
Monday, my lord. Monday I got some.
Wednesday, I said.
Very well.
Wednesday.
Let's 19, my lords, I appear for the
19, I'm for the petitioner. Good.
17 itself. Let's now 17. This is covered, my lords, by the latest judgment of the apex court, squarely on the point. Squarely on the point. It is not.
Him say what is the point, then you can
Yes,
say.
yes,
how
yes.
it-
So execution petition has been filed.
What is the impugned order in this?
Madam.
Impugned order
Madam.
is at
Page number?
1 second.
That's impugned order is at page number 117 and 18, madam. My lords, 117 and 118.
Your lordship is holding WP 69/2000.
Yes.
Page number that is
Introductory
107.
application under 151 of the CPC. With article 136 of the Act, you have rejected.
Holds that the execution petition is in time. So judgment debtor is in writ petition, please, lords.
Judgment of an introductory application.
On
Call the
232.
order of attachment of immovables against them. To dismiss execution as it is barred by law of limitation. So the court said it is not barred by limitation.
Yes. Now my respectful submission, 232.
Why it is barred by limitation?
No, because the dates are important, that's all.
Yes, please give the dates.
I have extracted in my objection.
232.
Column. My objections I have extracted the dates.
Yeah.
ಇದಕ್ಕೆ ನನ್ನ objection ಹಾಕಿದ್ದೀನಿ ಅದರಲ್ಲಿ extract ಮಾಡಿ.
Where are they?
Page number 2.
When did you file the objection?
Anyway,
Statement of
2/3/2002.
22.
So he says he has filed
I have
along with the
extracted.
objection. We can look at the
22nd April,
objection.
22nd April 2026 objections are filed.
22nd April.
Yes, my lords. And page number 2, I have extracted, my lords, the
It's not there, the copy of it.
In which petition, sir? Petition number?
Huh?
Petition number?
petition number 69.
22nd April or something is in
Yes,
January.
my lord. 22nd April, my objections are filed.
In the other matter or the first matter itself?
This matter I have.
Statement of objections,
Yes, my
yes.
lord. Page number 2.
2-3,
Page number 2.
wrote something like 2-3-3002.
I'm sorry, my lords.
No, that's what synopsis have prepared. 2/3/2002 is the trial court.
2002, my lords.
Trial court passed the judgment and decree, please, lords. Next submission.
Yes.
And then company questioned the judgment in RFA 950/2002 on 11/9/2002. And 23/10/2009, the said appeal was dismissed. Then 27/6/2019, the respondent, that the decree holder, filed execution. That is after lapse from that day, 2009 to 2019. Then after service of notice, they said execution petition was filed.
No,
Then
2024 writ petition was dismissed.
What?
So in 2024, some writ
the
petition was
executing
pending.
passed because I have taken a maintainability with regard to maintainability, not with regard to limitation. That is totally different, this thing. So that was dismissed as against that. Now a new
No, in 2024, then that writ petition, whether the execution proceedings are stayed or not.
in 21, please, madam.
This
No stay.
number
No, that's what, that is my specific contention. From 2009 to 2019, there was no stay order.
no proceedings are pending.
No,
anywhere.
except this appeal, no other proceedings are pending. So now my grievance, the only short point is that is the only point.
So
Now,
from 9 to 19, it's part of a limitation.
that's what.
What is your submission?
My lords, my respectful submission is the apex court clearly holds, my lords, identical case which went up, my lords, very recently, my lords, before the apex
You
court.
have the copy of the.
Just
I have given it, my lords.
Just have.
I have given it, my lords.
I'll look into it.
But kindly turn to the para 21, para 21 of the judgment.
He wants to
That-
look at that.
Please, my lords.
He wants to look at this judgment.
Nothing, my lords, it is a clear case, identical case.
I'll
same
have this
case.
partner on Monday in the first list.
May I make
Please,
submission?
please,
madam?
Monday.
I'm traveling.
There is some urgency, my lords, for
Your
us.
lordship may kindly treat it as parted. I'm traveling till 19th. I'll not be there, my lord. So that if your lordship accommodates on 22nd, I'll argue the close the matter.
Even to 3:30.
Then, no, we'll do one thing. This matter on 22nd,
Yes.
on the top of the list.
Please,
Top.
interim order may kindly be.
Interim order.
Because what happens is, we have to.
No, I'll
recover
also
our
come
monies,
prepared, my lord.
And they have substantial
That
money.
day I will not adjourn the
Yes,
matter.
No, I'm
clear,
not
my
on
lord, see, Supreme Court has held, my lord, very clearly it has held, my lord. Para
That day
20.
we'll see.
Yes.
Yes.
Cell number
Same
18,
case, it is the same case.
38.
For respondent number 5.
For
in this
filing
case.
objections by the respondent.
For objection,
There is a stay, maybe extend.
then council.
Lord, I am
then-
filing a memo for the building condition, Lordship. The building is in dilapidated condition, Lordship.
That
Photographs.
will be, along with the objection, they have to file, let them file.
Leonard AG seeks time for filing objection. 2 weeks. For 2 weeks. Land
That should
counsel
be
for
after
the-
20.
Your respondent,
Five.
land counsel for the respondent 5 also seeks time to file objections. There's this matter on 2nd of July.
Stay may be extended. when-
Or stay granted earlier is extended. Yes, 19?
19, my lord, I am for the petitioner. They have to not file objection.
Huh?
After 23rd, because I am not there between 19 and 23.
I said July.
July 2,
July.
2nd July.
Fine.
Cell number 19, Sridhar Prabhu.
My lord, subject for
Petitioner.
respondent. I request your lordship to kindly grant 2 weeks time to file our objections, my lord.
Seeking time.
Please, of the interim order may kindly be extended. This,
You are appearing for?
Respondent number 1 and 2, we have filed wakalat.
At the request of land counsel for respondent 1 and 2, list this matter after 2 weeks. Interim order earlier granted is extended. Is passovers?
Pass over
Grateful,
matter.
my lord.
Serial number 5.
My lords, in this matter, an order returning the plaint is challenged in this writ petition, my lords. My lords, the impugned order is in page number.
When was the order passed?
My lords, order was passed on 24 March 2026, my lords.
Must have given 30 days time to you.
My lords, I was direct,
Court must have given time to you for representation of the plaint before the proper court.
my lords, the application of law
Hereby
is,
allowed director to return the plaint to the advocate for the plaintiff forthwith to present the same before the competent court have jurisdiction. Both were directed to appear before the jurisdictional court at Satara on 34/2026. What are you doing
my
from
lords,
there?
my lords, in this case, what has happened is, I applied for copy.
Doing from that day without even questioning this order.
My lords, in the meantime, the vacation has come, my lords.
Order is passed
My
on
lords,
24th March.
My lords,
April, you have full April.
please, my lords.
Notice to the
Please.
respondent.
My lords, on the wrong interpretation, because the trial court has passed an order to transmit the entire record to that court, my lords.
It was gone, 34.
My lords, if it is not sent, it may be stayed till then.
Percent. There is no wait.
My lords, because
Notice to the respondent.
Cell number 11.
date may be fixed, my lords. I may be permitted to serve on the
List
council.
to the respondent, petition is permitted to take out hand summons. List this matter on 29th of June.
Great, my lord.
11.
Petitioner, my lord. I have served a copy, my lord, on the Learned Council.
Yes.
The connection is the notice.
They say that you're going to disconnect the power supply.
Disconnection was not made.
Not?
Disconnection was not made. Notice was issued. Let file objections to this application, Lord, that till consideration of the objections not.
Will not do anything. Shall I dispose it off?
Dispose it.
The present writ petition is filed, seeking the following prayer. Land counsel for the petitioner submits that petitioners are the absolute owners of the property and are in possession of the property by virtue of a registered partition deed executed among his father, brother and sister. It was registered, it was a registered document. On 39/2023, the petitioner filed a formal application before the Mysore City Corporation seeking permission to safely demolish the pre-existing dilapidated structure on the scheduled property. On 23/11/2023, the Mysore City Corporation accorded its official permission sanction for the demolition of the old building by letter old building. The petitioners demolished the structure and constructed a commercial warehouse godown spanning a built-up area of 3,599.99 square feet. And the petitioner's name is mutated in the revenue records. Thereafter, on 27/2025, petitioner has submitted a formal application to the third respondent seeking an upgrade and enhancement of the entire electricity load from 0.4 kilowatt to 24 kilowatt under a commercial tariff to operationalize the newly built warehouse. But after technical verification and due scrutiny, the third respondent sanctioned and regularized the upgraded 24 kW commercial load by proceedings dated 37/2025, and the implementation was completed on 5/8/2025. On 11/11/2025, the old meter was formally and permanently surrendered to the respondents. A third party who has no interest in the scheduled property filed an RTI application on 6/1/2026, questioning the additional load sanction. On 6/4/2026, the vigilance squad of the second respondent conducted a sudden site inspection without prior notice or opportunity of hearing to the petitioner. Thereafter, the impugn notice dated 8/4/2026 is issued, giving a 7-day ultimatum to produce the occupancy certificate or completion report, failing which the electricity supply would be permanently disconnected. Land Council, appearing for the petitioner, submits that the petitioner, the respondents, without giving a reasonable opportunity, are going to disconnect the power supply, which made him to come before this court. Land Council, Mr. Devraj Chu, who takes notice on behalf of the who takes notice on behalf of the respondent 1 and 3, 1 to 3.
1 to 3.
Respondent 1 to 3 on instruction submits that. Now they have issued a notice giving him 7 days time. If the petitioner submits his explanation to the said note, give his explanation to the said notice, considering the same, they will pass appropriate orders. Until such an order is passed, they will not disconnect the power supply. Next para, having heard the council.
Subject to paying regular consumption charges.
That will.
Subject to
That
paying
is,
regular.
subject to
Paying
payment
regular
of regular
consumption.
consumption charges. Having heard the council on either side, there is a material non-record. The petitioner, what is questioned before this court is a show cause notice, and the land council appearing for the respondent submits that. Without passing a final order, they are not going to disconnect the power connection, subject to payment of the usage charges. In that view of the matter, this court is passing the following order. The writ petition is disposed of, directing the respondent. The petition is disposed of, directing the respondent not to disconnect the power supply until a final order is passed pursuant to the impure notice dated so and so. The petitioner shall submit his reply within when that 1 week will complete.
That's already lapsed, my lord, but however, on
Shall
understanding.
submit his explanation by 9th of June.
Yes.
Accordingly disposed of.
Cell number, that's clear, that data, please.
Yes.
Right.
What's this matter?
Who
Electricity.
appears? Electricity. Yes, Mr. Devraj. I think this matter also, have you served papers on him?
My lords, I've served it on the BESCOM office, my lord.
Give him, what is it, what is the threat now?
Lords, they've disconnected the electricity connection on
On the
3rd
ground?
of June, my lords, pursuant to notice at Annexure A, my lords. As per that, my lords, I've been called upon to submit an NOC, obtaining, getting the NOC.
Have you approached, have you responded to them?
My lords, because I was unable to procure all the necessary documents, I couldn't submit a reply within 7 days. Now, my lords,
You don't even go to him and ask him the time.
my lords,
And you come to the court saying that something is wrong with what they did.
lords, without passing a final order, my lords, they unilaterally come on 3rd of June. I come near the property and disconnect.
Final order
the
is passed in this. We'll do one thing. You just find out from your officers. You can come to the chamber and tell the court. Basing on that,
That this is with regard to the temporary connection for the purpose of construction. That it appears that BBMP has made that it is in. I kindly pass an interim order.
let
Fix
it
a date
counsel
that
that the petitioner submits that without passing an order, the power connection is disconnected. Let it counsel, Mr. Devraj, who is accepts notice on behalf of the respondents and submits that he would get instructions in this regard. Considering the fact that as per the material placed before this court, it appears that basing on a requisition made by the BBMP
and for non-production of the occupancy certificate.
For non-production of the occupancy certificate, the power connection is disconnected, and admittedly no order is passed so far. Hence, the respondent shall restore the power supply to the petitioner. The respondent shall restore the power supply of the petitioners. List this matter after 4 weeks. By the time, the respondent shall file their objections.
The
May I
restoration.
kindly say forthwith, my lords, because there is no
Forthwith.
Restoration.
From them.
And that I'll into. restoration, let the installation bearing RR number 4 ETP 31.
That is there in that? That is there in that.
There is there in the
order,
impugned
that-
order.
That you incorporate.
The
that,
impugned order it is.
where, whatever the bearing number,
Installation
so and so, the meter number or so.
Yes, request for hand delivery of the order, my lord.
Yes, hand delivery.
Lordship, morning's session, I moved a memo, my lord. Delivery warrant is already issued. I may be dispersed at any time, my lord. Kindly have.
It is there till 17.
70, already the delivery warrant is taken, my lord.
There will be a time and date mentioned on that you said 17. I'm not going to take up, give that memo, I mean.
We already filed, kindly have it on Monday, my lord.
Yes, let it come on Tuesday.
Kindly have it on Monday, my lord.
Purely, sir. 98428 23147 458 23147
ಅಲ್ಲ ಅದು ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಮೇಡಮ್ ಹೇಳಲೇ ಇಲ್ಲ ಇವರು ಮೇಡಮ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಇನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಫಾರ್ ಅಸ್ ಟು ಲಿಸ್ಟ್ ಇಟ್ ಆನ್ ದಿ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ನೀವು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀರಾ ನಾವು ವಿ ವಿಲ್ ಅಸೈನಿಂಗ್ ದ ಡೇಟ್ಸ್ ಮೇಡಮ್ ಟೋಲ್ಡ್ ಮೀ ಟು ಅಸೈನ್ ದ ಡೇಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಐ ಅಸೈನ್ ದ ಡೇಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ
ಇಲ್ಲ ಬೇಕಿಲ್ಲ
ಎಂಡ್ ಆಫ್
ಹಿಂಗೆ
ಇಲ್ಲ
ಆರ್ಡರ್ ಮಾಡಿರ್ತಾರೆ
ಮಂಡೆಗೆಲ್ಲ ಆಲ್ರೆಡಿ ನಿನ್ನೆ ರಿಪೀಟ್ ಇಷ್ಟೇ 100 ಮ್ಯಾಟ್ರ್